under God, indivisible, with liberty and justice for all. Please remain standing for just a minute. I'd like to ask everyone to bow their heads in a moment of silence for the three young students who were killed today down in the Covenant School in Nashville. Amen. Please be seated. Okay, the first item is to adopt the agenda.
So moved.
Second.
Motion and second. All in favor? Aye. Any nays or abstentions? Seeing none, the motion passes. The next item is a motion to acknowledge the minutes of the March 13, 2023 board meeting.
I'll move it.
Second.
Motion second. All in favor?
Aye.
Any nays or abstentions? Seeing none, the motion passes. The next item is a motion to open the public portion of the meeting. This will be to present comments to the board with respect to any of the discussion items and the board resolutions that are on the agenda tonight.
I'll make that motion. I'll second it.
Motion and second, all in favor?
Aye.
Any nays or abstentions? Seeing none, the motion passes. Thank you. So if anybody has any comments, please come on up, identify yourself, and raise it to the board. No. Madam Supervisor, Barbara Gutzler for the record.
Thank you. Excuse me. I'll try to get this out before I lose my voice. Good evening, everybody. Barbara Gutzler, 5 Russet Lane in the town of Wappinger. I just wish to address the board on something of which I'm quite confused, and that's the new rules of the town board that are proposed. Specifically, it reads here, number 15, that there'll be a time limit on meetings, discussion, and resolutions, I think to end by 9 o'clock. So I'm going to ask you for some clarification. Okay, the first thing is, does this mean that there's a time limit on the meeting itself? Does the meeting have to end by 9 o'clock?
Absolutely not. I'll clarify that because that's one of the ones I'm bringing forward. So what we're looking to do is we have our meetings that go till 11:30, 12:30 sometimes, and we're looking to cut down on that. So we're trying to find ways to do that. This is just a suggestion out there, 9 p.m., but certainly it's not going to be totally enforced because we know there's extenuating circumstances. You have public hearings, people want to get up and speak. So again, it's kind of more of a guideline than a firm, I'll say 9 p.m.
Okay, well then why, if we say we can change that or there are extenuating circumstances, why bother to put it in writing? It seems like it's another regulation that won't be enforced.
So the reason is it's more of something of discussion. It's on a discussion. So it's not like it's a firm 9 o'clock. So again, I just wanted to put it out there because we want to talk about it. We've talked about it for a long time, about our meetings lasting as long as they have, and we want to try to make things flow. As you look at other towns, meetings go certainly a lot quicker than ours do. So again, maybe we want to take a look at some of the things they're doing versus what we're doing. But again, it's not a hard and fast. It's just kind of, hey, let's have a discussion. If 9 p.m. doesn't work, 10 p.m., we're going to do what we need to do because residents need to be heard, and so we're not going to stop them.
Well, then why even bother putting it in, really? It seems to me that because there has been some rather tense discussion over the last few months about, Cedar Hill Road, about the Houstonville gas station, people have said there's been misinformation put out here, put out there. People want clarification. And people are concerned about the character of their neighborhoods. This almost comes across. And I really, quite honestly, having sat up there, I really have to question motives. It almost sounds like you want to shut down discussion and just, allow me to finish before I, be happy to, listen again. To shut down discussion on things like this. People are here, and if they're going to be here till 11 o'clock at night, they're going to be here till 11 o'clock at night. You're not going to turn into pumpkins, okay? There are many times when I was up there, we were here till 11, 12 o'clock at night. And you knew that when you ran for the job. You knew that, okay? So quite honestly, from my standpoint, that's not valid to say the meetings go too late. That's not valid. The issue is what brings people out. And if people are concerned about protecting their Houstonville neighborhood from a gas station that they didn't want, okay? I don't think very many of us really wanted it, okay? And also, they want to protect Cedar Hill Road, and what concerns me about that, even though I don't live there, is, you know, I recently retired from the Transportation Department in the Wappinger School District. You're going to increase traffic on that road, okay, and I'm concerned about the school buses and everything else. There's a reason people come out. It's the issue. And to say that there's a rule on the town board that we're going to end discussion by 9 o'clock, in my opinion, is just trying to shut down free speech. And even though you say, well, we could change it, the fact is you have it in writing. Why have it in writing if you're not even going to enforce it? You might want to think about limiting comments to 3 minutes.
Well, I think that's what we try to do, so,
Yeah.
you know, let's...
So nobody's trying to, so please don't insinuate anybody's trying to stifle anybody's opinion, because we're
Well,
not trying to do that.
That sure is what it looks like here.
No, but that's not what this is. This is try to make meetings go more efficiently, and if we need to move things out, you know, say, for example, if you have a lot of discussion, maybe you think about moving things out to another meeting, because you want to allow ample time for people to be able to have the opportunity to speak about things that they're concerned about. So again, not trying to stifle anything here. Put 9 o'clock out there. Maybe it was wrong, but we're not trying to stifle. You can stay till 11:30, 12 o'clock, 1 o'clock. I don't care. We seem to do it every single meeting, Barbara.
Well,
So again, if that's the case, that's fine. We'll go ahead and hear the comments.
Look at the way you folks are running.
Okay, let's not argue
Okay.
right now.
All
Let's
right,
move
bottom
on
line
to
is,
the
I
next
just don't want
point.
to see Wappinger join the cancel culture and shut down free speech.
And we are
and
not
people
trying
say-
to shut
excuse
down
me.
free speech, please.
Pardon me.
I know you're speaking,
believe I
but
have the
please
floor.
don't make comments that are not true.
I'm sorry. You telling me not to make comments that aren't true?
Okay,
All right, well, that's going
let's
to
not
turn
get
personal
into
then, Al,
anything there.
because
Stick to the
I think
Let's just stick to the
you
agenda, please.
are not the person to be making a comment like
Okay,
that.
okay.
But that's getting on the personal level, okay? I haven't forgotten. I haven't forgotten things that have happened.
Okay.
Please, you know, reconsider this, because it's denying residents their rights to come out and speak as long as they need to. Thank you for your time.
And I'm going to make a last comment. We're not denying residents. You had your turn, my turn.
Look,
I'm not
Al,
denying anybody.
Okay, no,
Al,
let's not argue.
just cut it out.
Please.
Okay? The
You
best
opened it up.
comment of all sometimes is just not to make another comment, especially when the person is turning away. Do not disrespect a tax-paying resident.
I'm not. You're more than welcome to continue speaking.
Okay. Yes, sir.
Gentlemen, I think you know who I am. I'm Kenneth M. Stenger. I'm very fortunate that my client's application is on the agenda tonight.
No, there's no application on the agenda.
I'm sorry. The
Yeah.
discussion is before the board on the agenda.
No, the agenda item, to correct you, is to, you know, exactly, it says acknowledge application of Mid-Hudson Development Corporation. We're not discussing the application tonight.
I wasn't intending to do that
Okay.
now either.
Yeah.
I just wanted to say that it was appreciated that we're on the agenda and not subject now to the rules you wish to consider to change with respect to now creating a sponsorship requirement that does not presently exist in your rules to allow people or applicants to be heard before this town board. I can appreciate that you may wish to look at a process that creates a more orderly fashion or a hierarchy of what's on the agenda and what's not, but I offer you a word of caution, and that is simply on two levels. One on a very general level, which is that the people that wish to have things placed on the agenda are not internal or external persons. They're the people that elected you and have agreed to allow you to govern them. And that's a huge piece while you're balancing out what's efficient in conducting the town's business and what is not. And so I offer you no criticism or guidance other than my wish that you be cautious in how you address this issue. Because you cannot, you will not wish to be, and I'm very cognizant of your comments, Mr. Costello, to be viewed as the people are the people that stop things from being on this agenda. You're not the gatekeepers, you're the board members. And in particular, I will just go back to the discussion that we will be having shortly My client proposes to ask for this board to take an action under a section of the town code which says the only board or entity in town hall that can take this action is you. And under that circumstance where the code says you must go to the town hall for relief, you would expect that the town board would not say in advance, prejudging anyone's application under that circumstance, that no, you didn't have a sponsor. We don't want to hear you. So there are distinctions. They are subtle. I appreciate the need to control your agenda and organize it and make it efficient. But in that process, keep your eyes open for the distinction. If your laws say that people have a right to come here to the town board for relief or authority, or specifically your laws say, go to the town board and ask them to do this because they'll consider the issue and say yay or nay, that shouldn't be conditioned on sponsorship. If it is, it's just pure politics. And pure politics is not I love pure politics. Everyone in this room knows I do. But we all know pure politics is not good governance. So thank you, and I wish you luck in your task. And I ask you to please keep in mind the distinction between what the law says you must hear and what you may not wish to hear. Thank you.
Other comments?
Morning. Good afternoon. John Gorman, 6 Thompson Terrace. I'm here yet again as a concerned lifelong resident of this town. I'm concerned that I have to come speak yet again against a project that has already been turned down by the board updating aging local laws. I'm concerned that the developer is asking the elected officials whose responsibility is to represent the people of this town to constantly fill up the agenda with their proposals. There's one way you could streamline your meetings. Stop letting these guys try to go around and try different ways to get through their proposals in. I'm all for free government, but this is another way we're wasting our time, our tax dollars. This is like when my 4-year-old daughter asks me for ice cream, I say no, so she's trying to go ask her mom for it. This is the same thing that this panel is doing, this developer is trying to do. You guys said no, so now they want to go to the planning board, okay?
I will interject. We never said no. The application's never been before us, and we're not considering the application tonight.
The law was
okay.
Okay. But this is what they're trying to do. They're trying to go to the other governing body. We don't need this development. We don't want this development. All we want is to have our lives protected and that stay the same way we are. I know anybody that's been up on Cedar Hill. I live up there. I have a 4-year-old and a 1-year-old. It is a racetrack when people trying to cut through Old Hopewell and 52 or Old Hopewell up Relier Terrace. It is bad. If you've been in that area, it is bad. I don't let my kids even go near the intersection of the road without us within 3 inches of them. Adding more hundreds of people in our town is not in our neighborhood is not necessary. Our town board was elected to uphold our town codes and our town comprehensive plan for a reason. This exact proposal goes against all of that. So I'm asking you, elected officials, to stand up for your town and stand up for us. Thank you.
Thank you. Other comments?
Good evening, guys. My name is
Good
Matt Nataro. I live off of Cedar Hill also. I know John, I know Chris, nice guys, don't get me wrong. I'm here for my own because I live there. I just don't know how many times we have to come here, and I'm not even sure how this whole process works, to be quite honest with you, but how many times I have to come here and other people before we say, listen, you bought a Chevy, you got a Chevy, it ain't a Cadillac, I don't know what to tell you. Cut the trees, put up your one-family houses and move along. You know, I just keep coming back and back and back, and I don't know when it stops. I mean, is it the water moving the rock theory? You know, it just keeps, moves it through persistence. You know, I just don't know when it stops, you know.
I think in answer, there's been no formal application accepted and before the board. The last time we repealed a code section, we were all unanimous that, was eliminating a way to get past the board, okay? So we ruled on that.
Okay.
Tonight, we've received a letter from Mr. Stenger asking for application. All we're doing is really accepting, acknowledging that, or may not, tonight. the town code provides a process which was also discussed at that, last meeting on the repeal. I'm just trying to
I
explain to
appreciate
you,
that.
right? In that particular case, what we were opposed to was not coming to the board. But there are other provisions in the town code, which, I think our council can explain, do allow a party, any landowner, property owner, to come before the board with a formal application or to go before the planning board, within the parameters of the code, sections, right? So that's what this board as a legislative body, if it is officially before us, would be considering. And then we have to go through a process, where we review that specific application, have comments. So that last time that you were here, and I would appreciate the comments, was to talk about the repeal of that code section, which we did repeal unanimously. So now we're looking at, unfortunately, in the context of people coming out at the same time, but appreciate your comments and patience, looking at it from a different set of glasses because of the process that was established by the code repeal, which creates these, conservation, aspects to subdivision with cluster planning, which is clearly discussed in our comprehensive plan in a number of sections in the comprehensive plan, what could be acceptable. I'm not saying it is because we're not, discussing this, tonight, but I just wanted to explain that there is a process and procedure. So because one thing may have been considered in the context of a different law, such as the repeal of that code section, doesn't mean that we've ruled on the merits under that particular code section for whatever the bigger project was. That's all.
I understand too, if you say no to this, you can change it up. The developer, his option is his property, change it up to more conform or to get it to be more acceptable or palatable or whatever, and reapply again. The question I have, I guess, is how does the process work, right? So I understand you're not taking an application today or from Mr. Stanger's last comments or something, but if you were to take an application, let's just say, right, if something was put forth by John or Chris, their company, do you then review it and then put it up for public review or discussion or this? Or do you just get it that one time and then you guys make your own
Right.
decision? Or which one is?
So I think there's, and correct me if I'm wrong, counsel, there are, several different ways that our code and the law allows us to address it. One is you could come in and make the proposal, right, an application, and under our Constitution, everybody has a right to petition. So
As we
there's no
should.
question about that, as we should. The board, as a legislative body, has several different options, one of which could be to say no, right? And then probably litigation involves, just like it has in the
As we
past
should.
against the town.
Yeah.
Another one would be to say, okay, we want a preliminary opinion or some other opinion from the town planning board, or perhaps there's a zoning issue that's not within our area, like a variance. So then on that particular issue, that could be said, okay, we'll request the planning board to go and consider it and then come back to us with a recommendation. There's several nuances to that, but basically that's what happens. Or the town board, the third one, could be we review it and grant it, but that won't happen under a number of circumstances until there's at least one evening for public hearing, and in our experience, likely to be more than one, evening, where everyone has the right to present, their, opinions, comments, recommendations for the board to consider. But we are a legislative body, and therefore looking at it from that point of view.
So is it fair to say that if it was submitted, it was reviewed, it was, I don't want to use the word approved, that's a bad word
Right.
to use right now, and I don't mean in this
Maybe
context.
accepted or something, I don't know.
Right,
But-
there would be some type of this before
Yeah.
the final
I mean,
stamp on it.
I personally, I think I speak for all of the board members, would ensure that that occurs. We don't have any intention, to act otherwise. And I think that when, the rule changes that we're just talking about, I don't believe, at all intended to stop to prevent someone from speaking. And in fact, I think the councilmen and women know that if in fact there was that effort, I would have opposed to it, and I would put something on the agenda as being the supervisor
I
of
can
the
say every
town.
time I've come
right?
here, I've been allowed to speak
Right.
without
And
time
that-
limit, and I
Right.
appreciate
And that will continue, I assure you, and there's nobody here that objects, to that at all.
I won't take
Okay?
any more of your
Oh, no, we appreciate the comments and want to clarify it, because it's not a simple issue. Plus, we do have somewhat of an old code. We have a comprehensive plan that's never been reviewed since 2010 that has a lot of provisions, which clearly, the environment of the town has changed, although the general nature of the comprehensive plan is probably still very solid with it. But yes, there would be clearly that opportunity, and as there has been in the past, the opportunity to present something in writing as well. You always have that ability to, as part of that petition review process, submit something in writing, or even have your own legal counsel if you wanted to go to that expense. Certainly not Mr. Stenger. He charged an arm and a leg plus some, but...
I didn't even...
But anyway, Jim, have I overlooked anything in the summary? Or-
Well, let me just talk more in a general overview.
Don't bill this by the hour. Just...
Okay, right. But with respect to a subdivision application, so basically there's a typical subdivision application where an applicant comes in and looks to develop a certain piece of property. So for example, let's say you have a 100-acre property with 1 acre, with R40 zoning, which is 1 acre. So theoretically, you could get 100 houses on a 100-acre parcel with 1 acre zoning. We'll do that, that's kind of the short end of it. It's a little bit more complicated because from that 100 acres, you would deduct wetlands, you would deduct steep slopes, and I believe we have a provision where you would deduct a certain amount of road area. But, for...
I got you, for argument purposes.
For argument purposes.
100 equals 100.
100 equals, so you would have 100 1-acre lots, right? We also have some provisions in our code regarding, under section 240-19, which is called modification of lot requirements. So that basically allows for 3 types of development: an average density subdivision, a conservation subdivision, which is being proposed here, and then a mandatory open space subdivision, which is the 3rd type. An average density subdivision would be where, instead of getting 100 lots of 1 acre apiece, you could have 100 lots that average out to be 1 acre apiece. So you could have an acre and a half, you could have a half acre,
Yep.
but so long as the average comes out to be
100 still 100.
100, still 100. Conservation subdivision is you take the 100 acres and you figure out what the density is. For our purposes, 100. What the application then is that the applicant is then going to ask for a reduction in those size of the lots, and typically you can just go down, I believe it's 1, so you could go down to, rather than 40, rather than a 1 acre lot, you could have like half-acre lots, or you could have, our code also permits like townhouses. So what you would do then is you would then take the 100, and rather than spread them out over 100 acres of lots, what you would do is you could put them in, say, 30 acres on the site, and then the balance of the site, 700, the 70 acres would be preserved as open space and conserved, and 30 acres would have development. So that's what this is proposed as. And then the 3rd section, the 3rd type of subdivision that's permitted in that section is what's called a mandatory open space subdivision. So if an applicant came in with a subdivision and requested what we call a conventional subdivision, 100 houses on 100 1-acre lots, the planning board has the discretion to say, we don't like that. We think that's making too much, spreading out development too much. We would rather see that development constrained in a smaller area and preserve the rest as open space. And in that case, the planning board then has the ability to request that the town board adopt a local law, giving them the authority to squeeze the development into that smaller size rather than spread it out over the entire lot area. So And so the procedure is a little bit different with each application. For example, average density subdivision only stays at the planning board. That never comes to the town board. Conservation subdivision, open space subdivision, both come to the town board. And the town board has the ability to impose certain conditions on that, with respect to,
Does the town board have the ability to yay, nay it without it going to the planning board?
Yeah.
2 out of 3?
Yes,
Yes.
They do?
Yeah.
Okay.
Now, but that doesn't prevent the development.
right.
If the town board says no, then the applicant has the ability to go in and build 100
Change
houses
something else, right.
on
And I'm
100 separate
And I'm
lots.
sure they're going to build something, and I agree with that.
Right.
It is, they're a good company, they build nice houses. I'm sure something will be built, as it's their property, it should. I don't disagree with that, it's just the way, obviously, that everybody's concerned about.
Right, I mean, what these, these are, the terminology in general planning terms are for conservation subdivision and open space subdivision is what we call cluster subdivisions.
Okay.
So you'll see it in, it's very common in rural areas where you've got a working farm, and a working farmer wants to, put a portion of his farm into a subdivision, and he may take 30 acres out of the 30 acres out of the 100 to build a subdivision, and then he enters into a covenant to keep the remaining 70 acres as farmland. So that's something that happens as well. But that's the typical, and that's, that's what the current planning
Trend.
principles are.
Okay.
So, if you went, that would, that's very common. The New York State Planning Federation has a suggestion that that's the way to do it. The Greenway principles, talk about that. So that's
Thank you.
basically how it works.
Well, thank you, guys.
Sure, you're welcome. Thank you for speaking. Yeah.
That was well explained, Jim. Thank you.
Yes, it was very well. Anybody else?
Yeah.
Okay.
Come in.
Hello, I'm Bernadette Bodie. I live on Winfield Terrace. Thank you for that explanation. It's very helpful. But I just want to share something with our board here. When most of us that live in the Cedar Hill Road, Pine Ridge Drive neighborhoods, when we bought our houses 20, 30 years ago, we knew what land was near us. We also knew that that land is mostly unbuildable because of the topography, because of steep slopes, because of limited access to the major roads. So by developing that at higher densities, what you're doing, or what you would be doing if you agree to anything like that, is to just take away our neighborhood from us. It's detracting from what we have. I was driving around this weekend, and everywhere I'm looking, I'm seeing trees down, lots and lots of trees. Those trees, that's one of the riches of Wappingers. This is a green community. When I drive down Old Hopewell Road, it hurts me every time. I used to love coming down on a fall day and having the light hit the golden maples. And it was beautiful, it was breathtaking. And that's gone because we had to expand Old Hopewell Road. We had to make it super wide to accommodate additional traffic. We're losing what was special about our community. While somebody might decide to make an investment, I don't know anyone who has a 401k around here, we know what happens to investments. Sometimes they just don't pan out. And that might be the case for some of these developers that have scarfed up land in the last couple of years, that they don't get their way to put in a massive amount of houses or townhouses or cluster developments or whatever else. We're a community. We shouldn't have this all imposed upon us by people that don't live in our neighborhood. I mean, it's ridiculous. We're getting it on one side by O'Donnell, we're getting it on another side by this development, and then there's this big patch of land right in the middle that's going to be the next project coming forth. It's intolerable. You're taking away what we all love about our community.
Hold on. We're not taking away.
You're not taking, no. But if you allow, intense development, I mean, those properties, they're landlocked other than touching on a couple of, small footprints. I mean, they don't have, if you don't allow roads in there, they're dead. They have one little piece of frontage on the street. They're dead in the water, So it's just very upsetting to have to feel like we're battling this machine that's coming at us constantly, and it's just not letting up. There's no reason we have to throw away the comprehensive plan that earmarked that land for R40 development with acre-sized lots, knowing full well that not every acre was buildable. Thank you for your time.
Thank you. Thank you.
I think we just have to, need to clarify here that we took a position as a board unanimously previously before many of the same people that are seated here this evening in an effort to protect this town. And I believe that we made the right decision by doing that. I do understand there's other ways for developers to approach these types of situations, but correct me if I'm wrong, Mr. Haran, any approach now has to be a legislative action before this board, correct?
Conservation subdivision, yes. I mean, if they wanted to go with a conventional subdivision for.
Right, so anything that would be high density with reduced acreage.
Well, again, so with respect to open conservation subdivision, you're technically not increasing the density of the
All right, so
parcel.
any clustering.
Right, you're
Okay.
clustering the development on the parcel, and, so at the end of the day, and that's one of the things that's in the code, is that the planning board has to make a determination as to how many lots would be permitted as of right.
Right, so I don't think you're going to find a board member sitting here that's advocating for development in any of those three locations, that's for sure. And the position we took unanimously at that previous meeting, I think should be understood that that's our position.
So for the record, this is not considered to be a rezone of the property.
Right.
Correct.
Right.
And I think from a development point of view, Bill, what's allowed under the zoning code, that we probably don't have much say in how we control that, correct?
No, if somebody wants to build 100 houses on 100 acres, I mean, that's something that's permissible. I understand that.
Yeah.
It's still America.
Right. I mean, people have a right to develop their property consistent with the existing codes. And I'll just say this briefly, as I said at that previous meeting. I live in a 1-acre zoned development myself, right? So I wouldn't expect there to be a multi-dwelling complex being built within my cul-de-sac, right? So that was the point of my position that I took, because I feel like if it's going to be considered, it needs to be more than a special permit process. It needs to be a legislative action by the town board, which allows for the public to be notified and speak on these types of actions, which, in my opinion, is the fully most transparent way to make sure that the public knows that something like that is going on. And I'm just looking at this from my perspective, living on a cul-de-sac, and I think it's an R4080, right? Somebody could come in and say, okay, my neighbor across the street, there's a lot back there, they could build one of these types of things across the street from my house. I don't think that's right, because I don't agree with it moving into a neighborhood that I know is zoned a specific way, or living in a neighborhood for 30 years that's zoned a specific way, and have this type of application be able to be received. No disrespect intended to Mr. Stenger and his applicant.
No,
okay,
that's
I understand that, and I was here for the comprehensive plan in 2010. Clustering was a fashionable trend in previous decades, right, Jim? I mean, there
Still is.
You look at Hamlet Court, you look at some of the neighborhoods in our town, there were efforts to do that, to create green space, create boulevards, things like that. I get that. I understand it had a purpose, but I happen to believe now in 2023 that it needs to be a legislative action rather than a special permit process. That's just my position from this side of the dais.
And I think that's what we're all saying. I don't think there's anything inconsistent with that.
I'm not sure of the process here tonight, but as I understand, you will acknowledge receipt of what we've
Right.
submitted.
And you can summarize what you submitted, but we're not discussing the application.
That's
tonight.
fine, but it's good because people are speaking, and I think an informed audience is the best audience, and I really wish to thank Mr. Haran because he gave a very cogent distillation of what the law allows and requires in this town, and it is the law. And as much as we may subjectively wish it weren't the law, it is the law. And so there's an obligation sometimes to follow the law, even if you're unsure of it or if you feel it's unfair. But the best thing is that everybody understand how the law operates,
Right.
which is what's just happened here. And I thank the board, I thank the audience for being interested in it. I think Mr. Haran. But I wanted to remind you guys, the board, that I was here on January 23rd. My client had an application that had not been considered by this board under Section 240-50, which was a statute that you repealed that evening, and that's been referred to many, many times here. But I think it's important to remember what was said that night, particularly by Councilman Phillips. In order to repeal Section 24050, there were objections raised by the County Planning Board that this was a tool for flexible development, that the board had an obligation to show why repealing this was a good idea in terms of the overall need for housing other than housings on cul-de-sacs, which I personally enjoy. And your board passed a resolution that night that you amended with 6 paragraphs. And Mr. Phillips read all 6 paragraphs. And all 6 paragraphs said, you know what, we can repeal this because we have Section 24019B, conservation easement, conservation subdivision. And because we have that, because that statute is alive and capable of being used in the town of Wappingers, we don't need this section. We don't need this statute. We're just going to repeal that statute because we don't need it, because we have 240-19B. Well, my client's application, the one that you're going to acknowledge later this evening, is made under 240-19B. The statute that you said was the reason why you could eliminate and repeal 240-50 without concern, because the comprehensive plan values were still reflected in the code without 240-50. And I'll be honest with you that that night I met with my clients and we reached a consensus very, very quickly. We said we're not going to go into this fight with the town because the town has made it very clear that the preferred path is your section code 240-19B. That's why, in my opinion, your repeal of 240-50 would withstand judicial scrutiny. I remember saying it the last time I was here, which is, you folks have got to put some reasons on the record as to why you're voting to repeal this. Well, you did. You put them on at the 11th hour. I don't know that that necessarily complied with the requirements of the open meetings law, and maybe we don't have to find out. But I can say this, I'm listening to this board. It's pretty clear to me that no one on this board, and I get the fact that it's a political season, and I get the fact that there are folks coming up here. I find it interesting, people saying, we don't want this kind of housing here. We don't have an application submitted. We don't have a plan for development that anyone can look at. I don't have one I can show you tonight. And yet, I have people in the audience saying, well, we don't want this kind of housing, not in our town, not in our neighborhood. So that's politics, and it's not facts. That brings us back to what I said before. Politics is fun. I've enjoyed it, but it's not good for governance. And I would conclude this by saying, thank you for acknowledging this. I don't want to speak to the merits of our application or not. I would prefer, rather, that Mr. Haran be given an opportunity to develop a process that he can share with all of us so that when we have this conversation, it's an informed conversation. But when you consider this acknowledgement tonight, I want you to remember, each and every one of you, and Mr. Phillips, you particularly, because you're the one that read it. 240-19B is what you said was the reason why you could vote to repeal 240-50. Don't change your mind now.
Doesn't mean I disagree with you.
Don't change your mind now, because that court can always come back and take a look at what was said. 240-50 can come back alive. We're very happy to proceed under what your direction was, Mr. Phillips. And that's what we're doing here tonight. So we don't have a plan. There's no reason for me to speak to the acknowledgement. I want to thank you for acknowledging it. You can have a discussion if you want. I'm here. I just wasn't sure if you're supposed to wait or not. But this is a good time to say it.
Let me just comment, is in that we haven't said no to that approach. I think we're saying all here tonight, there is a process and procedure that we agreed upon, and that we will be, as you just said, getting the advice of counsel and looking at how we proceed from there. Since you did submit a letter, I wanted to make sure that we acknowledge that receipt, and we were going to be looking at it, going forward. I haven't heard anybody say, no or hell no, that, they're predetermined on that. We do owe you a fair hearing in the audience, and then to comment on that, and then make our decision, accordingly at that point in time. There's no prejudgment, I don't think, at this point in time, other than we've already been considering some of this, and we will go forward with that process in mind. But since we don't have that formal process, then we need to establish it so that, again, it's transparent and open, to the public, as well as to the board and our consultants that will advise us. Mr. Stinger.
Just a point of clarification, Mr. Horan, 240.50, which was repealed, was a special use permit process, correct?
Yeah.
Yes.
And 240.19B is a legislative action, correct?
Yes.
Okay, so there's a distinct difference between the two sections, and
Yeah, exactly.
the purpose of me bringing that up previously was because I believe, and I believe my colleagues do, the legislative action provides the most level of transparency for the neighbors so that the public hearing process is more accessible, whereas a special permit use is less transparent. That's my position and my opinion, and that's why I agree 240.19B is a better approach, just as Councilman Phillips said previously, whereas that is a legislative action. Thank you.
And to the extent that you did not get back your deposit for your previous application after we repealed it, then you have that right to go and get that returned. Well, you have to resubmit it.
Is there anybody else?
Anybody? Yes, ma'am.
My name's Suzette Merritt. I reside at 33 Truffle Ridge Road in Wappingers Falls. This project, while this one does not specifically impact my property abuts the Pine Ridge project, and I believe that if this is passed along to the planning board, the next is for the Pine Ridge Road to go through. While the supervisor spoke about transparency, I would just like to say that in our local community, we haven't been receiving information either, have not been any communications openly distributed to us other than one particular elected official who has advised our community of what's going on. I only found out about this being on the agenda today through our legislator. And again, these are important issues that involve and impact all of our communities that surround this area. And with the discussion of transparency, I just feel that there should be more information provided to us in the community so that we can have more information available to us to have these educated conversations and to adequately represent our positions when these meetings come up. And I just wanted to say that because, again, I only found out about this a couple of hours ago, and I came here straight from work so that I can make it known that while this particular does not impact my property, the next project does impact my property. We own almost 4 acres, and that project directly abuts our property line. Thank you.
Thank you.
Thank you.
Any other comments?
Good evening. My name is Cliff Chapin, and my wife and I live on All Angels Hill Road. I do appreciate the education that you've offered us tonight because it is confusing, and most of us don't have a good understanding of it.
And that's why I put this on as acknowledging the letter, so we would have that opportunity to explain it to you, before the next, event happens.
Yeah,
whenever that
and I
may be.
appreciate it, and I feel more comfortable with the some of the explanation that's occurred here tonight. And as I also understand it, so for all the meetings that we've been to so far, now is the first time an application has been submitted. Is that?
I don't believe there's any application.
yet.
There's actually, as the supervisor said earlier, we're in receipt of a letter with the intent.
Right.
There's no application as of yet.
Okay.
And that letter is part of the packet, that is available publicly. Our town clerk goes to great effort to publish and to get it out there. So that's in the packet that's put on our website, correct, Joe? And we get that information out there as to
Everybody can
whatever's being
see that,
considered there.
right.
That's publicly available, always.
And you can go out anytime to see it.
Yeah.
Like even after this meeting, that information stays on the website.
And anybody that ever wants a copy of it, then we'll supply it. We don't have any more information than that ourselves, so, but if we do, it goes into the record.
At some point, though, presumably, it's going to get to a point that will be in front of the board.
Correct.
Is that?
That's what we're hearing tonight, that they intend to submit an application.
So for all the education that you've offered, I really only have one question, I guess, is once at least one of them gets through and kind of goes through the process, depending on how you decide on that particular one, for other projects that we know also are kind of out there in the wings, do they all have to come up under and go through the whole process, or having looked at the area and made a decision, is that something that the board at that point can choose?
Good. No, it's a good question, and I think fair question. We've had some discussion. Of course, each property owner has a right to petition, right, and to submit that. We have nothing else. In fact, some of the others that have been talked about, we have not yet ever received an application. There was more, because of our interest to get the information out, really more in educational hearings, right? So that people would learn before we ever even got to that application stage. So we would also get a feel for what the people are talking about. So there are other things that could be done. I have and will be discussing, other legislation with respect to the environment, which is already in way, including water source protection. There are things that the town board could do, such as a moratorium, on different aspects of that could perhaps delay any developer or from putting into a project. Could be. I'm just explaining as part of the education what we said earlier, other stuff that the board can do. It can deny, right? It can, refuse to consider. After considering, it can deny along with stating the legislative reasons for that. As Mr. Stenger correctly stated, we have to state why, we are considering something or not considering it going forward.
I guess really I was just trying to understand, like, once the consideration has gone through the process and been given for future projects, basically asking for the same thing, does it have to go through the whole process again, or does the board?
Yeah, they again have the right to petition.
Sure.
Each, and we're not considering anything in bulk because each project is different from that. But let me just, it's a hypothetical, in the case where we think that there's a tract of land, and this had been discussed before with respect to it, well before myself, all of us, except for someone on the planning board and probably Bill, another tract of land where there had been a lot of discussion about this, and that still hasn't been developed. In fact, it's addressed in the comprehensive plan. So you look at how a large tract of land might be treated, which could be contiguous properties as well going forward. So, we do consider, we're very actively considering, because we had major study, which we'll be talking about further with respect to our aquifers. So if we were to determine as a legislative body that aquifers were being threatened by certain development, then we could take a different action as well.
And just so, make sure I understand, the current zoning for the area that we're talking about, the people that bought this property, they could go and build in accordance with the current zoning, and it would...
Legally, yes.
Legally.
Yes.
And then-
Practically, I don't know.
Well...
But yes, you're
again,
correct. They can go and take whatever that zoning allows on that acreage. I think we've heard numbers like 90 homes, 110 homes. I don't know what that number is, because then they have to look at a plan with, the slopes, with the ground conditions, everything else. Drainage, we're an MS4 community, so we take very seriously, this board does, the protection of, those aspects of it. So yes, but legally, they have that right to do it and would not have to come before the board if it was strictly within those confines.
And that land, the zoning hasn't changed, so, I mean, when you buy a piece of land that's zoned this way with a hope to build this way, I mean, that's sort of like an investment. Hey, this is risky. I can buy it cheaper because it's zoned this way, but then if I can get the board, and that's...
And there are changing conditions, like wetlands, right? We're seeing in this town that wetlands, at federal, state, and municipal level have been expanding because of the wet conditions, but also the nature of the topography, and that's another consideration. So if you look at what was on paper, the number of homes that may be able to be built, but the reality of it at the end of the day, and we strictly enforce our wetlands laws, probably not, right? Where that
Well,
is occurring.
I can confirm that the, being butted up against Sprout Creek, that the
that's
wetlands
right.
are expanding.
Right.
So, thank you very much for your
Sure.
time
Yeah,
today.
thank you. Appreciate it.
Just want to clarify, with respect to the discussion item, we have received a letter of intent from Mid-Hudson Development Corporation, is that correct? Or we have not received an application?
I think we have these two letters, right?
Right, so I just want to clarify, because on the agenda it says acknowledge application.
Should have been an acknowledged letter.
All right, so there is some confusion because it's articulated as acknowledge application. We have not received an application, we have received a letter of intent, is that correct or no?
Yeah, Mr. Field, that is correct. The statute doesn't require that an application be filed to have this board consider the relief under that section of the code.
Okay.
No development application has been submitted to this board. Part of the reasons that I appreciate our ability to be here is because I have a feeling this particular car hasn't been taken out of the garage for a while by perhaps this town board. And we would have the town board with council have the opportunity to look at the statute, as I have looked, and see what the process ought to be, so that there is a fair hearing for all involved. The folks sitting here concerned about what's going on in their neighborhood, I'm here because I'm looking at the law, and, I think that to clarify, there is no application, but the reason for it, Mr. Peel, is because the statute doesn't require it. But yet, we think that a process in which all people feel that they've been heard is absolutely essential to be able to take this statute and make it work.
All right.
So, Bill,
So what would be a more accurate,
I had originally put acknowledged letter, is
No.
what-
So-
Yes, it is.
You gave me, I have it
Acknowledged
here.
letter.
What you gave me to put on the agenda is the exact words that's on the agenda.
all right, so can we,
But it's supposed to be letter.
So what 240-19B says is, pursuant to 278 of the town law, at the written request of the applicant to the town board, the planning board may be authorized to modify the zoning regulation in one-family resident districts with respect to lot area and dimensions upon such conditions as the town board may impose, and provided that.
all right.
So technically, it is a written request of the applicant.
All right, so can we change the agenda so it says acknowledged written request from Mid-Hudson Development Corporation, and this is under 240.19B as in boy, so folks feel free to read that section, become familiar with it. 240.19B is the code section that this letter has been received under. And what confuses me here a little bit is many of these types of developments are handled primarily by the planning board, okay? Except if there's a rezone requirement, or except if it has to go through a section like this, then it would come to the town board for review and consent. A number of years ago, we made some code changes to improve the transparency of the planning board process. So you may see those little black and white signs that are on parcels around town where it says meeting coming up about this. So that's what would happen when it goes before the planning board as an application. This is a unique situation since we have people coming to us asking us to change the zoning or asking us for consideration under these types of codes where you don't see that. So when the lady mentioned that she wasn't aware of this, I thought about that. And the reason why you're not aware of it is because there's actually no application yet. This is still just discussion that's going on with respect to possibly being an application. So understand that we want to make sure that the public is aware of what's happening here, and I think we spend a lot of time to make sure that the public is aware. However, the cart is before the horse a little bit here because there's no application, therefore there hasn't been official public notice on things. That said, 240.19B is the section. Thank you.
Just for the record, I sent you the email correspondence from the supervisor reading, acknowledge application of Mid-Hudson Development Corporation dated March 7th, 2023.
Okay, so we'll just correct
We
it.
could just change it to letter.
We just
Thank
changed the
you.
letter. And that was the intention, as I said at the beginning of the meeting.
And it's important that you come out when you are made aware of what is on the agenda. This is your town. Your input is very important. You moved here, you like it here, your input we need to hear. So thank you, everybody, for coming. Is there anybody else who would like to speak? If not, I make a motion to adjourn.
Second.
Motion second, all in favor?
Just to clarify, we're closing the public.
Public hearing, sorry. I
Public
threw the hearing.
portion. Public portion.
Right.
Okay,
Sorry.
motion second, all in favor?
Aye.
Aye. Any nays or abstentions? Seeing none, the motion passed. Thank you. Okay, so then the first item is the acknowledge the written request of Mid-Hudson Development Corporation dated March 7th, 2023. I think we've had extensive discussion on that.
So if I may,
So what do you
with
do?
respect to, the way forward, as Mr. Stenger had noted, the last conservation subdivision application that was before the town of Wappinger was the Cranberry
No,
project.
that's what I was referring to earlier.
So in 2002, there was an application that was made. One of the things is that 240-19, I don't believe has been, I don't believe it's been amended since Cranberry. And so there's some kind of gaps here from a procedural point of view, in that, for example, it says in 240-19B2, permitted dwelling units in each case exceeds the number which could be permitted in the planning board's judgment if the land were subdivided into lots conforming to all the normally applicable requirements of the chapter. So that seems to indicate that the planning board, at least at some point, has to look at this. We also would have to conclude the seeker process, work on the seeker process, and make a referral to county planning. Perhaps some of the other agencies. At the end of the day, because this is an interpretation of a zoning code provision, Barbara Roberti would have to issue an interpretation of how exactly to proceed. The intent at this time is to basically proceed along the same lines that we did in Cranberry. And in Cranberry, it doesn't say it in this section, but in Cranberry, a local law was adopted by the town board. And then after adoption of the local law, the planning board then went forward on the project before it. So,
Cranberry was a conservation subdivision?
yes, it
Yes.
was.
Okay.
Which, for anyone that is not aware, Cranberry did not come to fruition, correct?
Yeah, no, it was, in fact, there was a bit of, Cranberry kicked around for many years. Back in the 1980s, I believe, there was about a 500 lot
It's the Ketchum Trails. That area back there.
Yeah, it's behind Ketchum House, between Ketchum and
Widmer Road.
Widmer Road.
Yep.
So it's, there was, the project, I believe, was 232. Ultimately, what was approved by the planning board was 232 acres, 232 units, and they were not able to, at the end of the day, the subdivision plat was not signed because they couldn't get a sign off from Fish and Wildlife.
There's a lot of wetland back there.
Which resulted in.
And plus then 2007, 8, and 9 happened where the bottom
Right.
fell out.
Exactly, so.
Jim, under B, it says that at the written request of the applicant to the town board.
Correct.
So it first comes to the town board,
Correct.
right? And then the town board can decide whether or not it goes to
It's
the
a
planning
planning
board.
board.
Yeah,
Right.
and the rationale is that, the town board, the request is to, in essence, give some flexibility in the design criteria. So it would be, in essence, unfair to the applicant to design a project and then pitch it to the town board, without knowing, in essence, you're not knowing what the design criteria is at the time. I mean, there's some suggestions, probably, but, the process, in some respects, it's the statute, the local law contemplates an iterative process, which I
Thank you.
believe is what happened in Cranberry.
So what, as far as what the town board does now, what's
So
the process?
what the town board would do is, I would request that the town board refer this matter to the Director of
Strategic Planning.
Planning and Codes to issue an interpretation as to what the procedure would be going forward.
Okay.
Move.
Second.
Motion and second, all in favor?
Aye.
Aye. Any nays or abstentions? Seeing none, the motion passed. Thank you. Okay, the next item is Buildings and Grounds Projects. Steve Frazier is here, yes, so come on up and speak. Thank you for everyone attending. Under the door.
Hi. First item is the title change among my crew that we've been speaking about. I'd like to move them into the groundskeeper position, which allows them to do some jobs that we have that currently aren't covered underneath the laborer title.
So this is generally speaking, right? You want to increase this, create this position generally, for the new title, or specific?
I'm not understanding your question.
Your proposal about the new title.
Correct.
Correct?
Yeah.
That is a general category that you would be creating.
Correct. It's a county-approved job title that is more fitting for the work that we do. We ran into problems where the laborer position, which they're currently in, doesn't allow them to do some of the work that we have that's off-season. Basically, that would make them restricted to grounds work. Initially, we had been bringing in seasonal laborers, and these were made full-time positions because we couldn't fill the seasonal positions, and then come to find out that we couldn't have them do the work that we have, that needs to get done through the winter months because it didn't fit their title. This groundskeeper title will allow for that. I had proposed $1 an hour increase. I did the math on this. There's 3 positions. I want to make 2 of those groundskeeper positions, which would add $41.60. The 2 positions would add $41.60 to the salary line. And then the third title I wanted to make groundskeeper 2, which would allow him to be a mowing crew manager then, and take care of that end of the jobs that we have, so I can focus on the bigger jobs and such. And I had proposed a $2 increase to that position, and all told then, between the 3 positions, we'd need a total of $6,240 added to the salary lines of the budget.
So these positions are new to the existing positions, right? You know, because we identify positions in our collective bargaining agreement. You know,
No,
these are,
the existing employees would move into these new job
I understand, but
titles.
you're creating new job titles that don't exist
Correct.
currently.
Correct.
They're approved by the county.
Correct.
All I'm saying is that we would need to have some sort of amendment memorandum to the collective bargaining agreement, I believe, you know, in order to.
Correct, and I have been in
Yeah,
contact
I know that.
with
Yeah,
the
that's where I was going to.
delegate,
Yeah, that's where I
and
was
he's
getting.
on board with.
So what are you going to do with the groundskeeper that you have that are seasonal? So
I'm
you're
gonna
going to move,
keep- He's willing to stay on as seasonal, and I'd leave him in a laborer position.
so how many groundspeople do you have today? You have part-timers, right? The seasonal ones, what are there, 3 or 4 of them?
Well, I have the positions that I haven't been able to fill. I have 3 vacant seasonal, well, I have 4 vacant seasonal positions. I have, the one person's been with us several years and has agreed to come back again this year. So in essence, I have 3 vacancies of seasonal workers. If I'm able to get them, they would, be an asset to the mowing crew.
Basically, what you're doing, though, is you're using some of the laborers today, you can move them to groundskeeper, they're going to be able to do the fields if you can't get seasonal workers?
That's going to be their focus during the growing season, is they are going to remain the mowing crew through the growing season. The groundskeeper position will allow them to do the repairs and such that we try to do during the off-season.
So my question is, if they're going to be doing groundskeeping, right, and cutting lawns, et cetera, are we taking them away from something else?
That's the job they've been doing. So no, we're not taking them away from anything else.
So they're doing groundskeeping today?
Well,
So in other words, you want to
the
make
season hasn't started yet. See, we do things according to what the weather allows.
Right.
And, during the growing season, I have a mowing crew that ideally the sports fields we mow twice a week, and the remainder of the parks we hit at least once a week, depending on the growth rate. That is their assignment through the growing season. Once the growing season, if we have a drought in the summer and the grass doesn't grow, well, then I can repurpose them onto helping the maintenance mechanics on the bigger jobs. But, during the growing season, their focus is going to be maintaining the parks. Then once that growing season is over, and we can pretty much declare it over about the middle of November, then I can start putting them into the other jobs that we do through the winter maintenance. But as it stands now, they're not permitted to do that work according to the laborer job title.
So they'll be able to do more work if they're in that groundskeeper than a laborer? Is that what you're saying? So if you
So-
promote them to the next?
The key term is in the groundskeeper job title in civil service. It says, as item number 17, may perform minor tasks of a semi-skilled nature, such as carpentry, welding, painting, plumbing, and minor electrical maintenance. That is not in the laborer title. So by pushing these people into the groundskeeper title, that permits them to work on those tasks and be working in title.
Yeah, what I want to make sure of is if they do get moved there, so they do have other skills that can be utilized, I want to make sure that we're not taking them away from doing some of those skills and now having them cutting the lawns, cutting the fields, et cetera, because typically he hires seasonal workers to do that, so.
So the term we've used was seasonal laborer, and again, a laborer is not permitted to do those tasks under the job title. So a laborer cannot do semi-skilled tasks. A laborer basically cuts grass, unloads trucks, digs holes. The laborer's position has, or typically, provides a variety of manual labor tasks subject to inclement weather, rakes and shovels, loads and unloads trucks, manually excavates and backfills, cleans streets, park areas, and culverts and basins, charges mixing machines with cement, cuts grass, works as a helper on a snowplow or sander. It's basically more geared for the highway department than it is for Parks and Rec.
Plus, it's non-competitive.
They're both in the labor class.
Right, okay, so the laborer is non-competitive, non-tested, and the groundskeeper is also non-tested?
Correct.
Okay.
Labor.
Correct.
All right, yeah, so then all we have to do is just change the,
Yeah.
change the
And
title.
so that's what Kristen Herzog, recommended.
Okay.
To address, Steve's needs.
So I'm,
We had looked at this during COVID, but
Right.
Steve never actually got the people to hire, so.
all right, I have no objection. What's the fiscal impact?
$6,240 per year.
Where are we going to find that? 6,240, you said?
Right.
Okay.
So you're going to have both titles open, Steve? Because as you know, it's been
No,
difficult.
there's not going to be additional employees. The same employees will move into the new
So
position.
you have you'll be able to cover these 4 slots? My point is, if you've been running into difficulty finding bodies,
Right.
if you have somebody who can run a mower but doesn't know which end of a hammer to hold, would you hire him as a laborer or a groundskeeper?
Well, with the new position, I'm going to be looking for a groundskeeper.
Right,
You know,
but in the event
push
that-
come to shove, I need somebody on the mower, then,
Right.
yeah, that's what.
Well, that's my question, because as you know, it's been difficult to find bodies.
No, I mean, and that's a fair statement,
So I'm just saying, if you have both options,
Theoretically, you could-
that's good for you.
bring them in as either option.
Yeah, I suppose ideally, I would like to, if it's going to be a year-round position, that we still have
sure.
the 3 vacant seasonal laborers. But for the past, almost as long as I've been here, I've never had a full employment in the seasonal positions. And that's actually what led to keeping the laborers on through the winter months so that we would be able to fill the slots. But, yes, I'll end up putting them where I need them, and, in order to get the parks maintained. I mean, that's our priority through the growing season, is the parks are maintained.
You will just have more flexibility based on the new
Yeah, during the
positions.
off-season, then, I have more flexibility in where I can send them.
Okay.
So back to the question, where's the money come from?
I don't have the money in my budget unless I eliminate positions. That's why I'm coming to you
Should we
folks.
just check with Frederick?
Yeah.
I did, I went with Frederick, and he had suggested the general fund.
Yeah, I mean, we got money in the A fund as long as,
It would actually be B fund, I think.
I'm sorry.
Yeah.
Well, we'll have to take a look at the budget. We have money in the A fund and B fund to do this. The priority here is to staff the team, because
Current staff is to address it.
I know for a fact that every municipality in Dutchess County is having staffing challenges, and now we're going into a season where we have to staff up, and we need to make sure that we have personnel to do what needs to be done. So there probably should be a resolution. Is there a resolution that indicates specifically the amount needed and where it's going to be appropriated to? No?
No.
No.
We could do that for them. I'll work with Frederick to get that for the next meeting.
Okay.
Okay.
And if
Do you have to
Frederick,
change the contract or get in touch with
We'd have to do probably a memorandum.
yeah, just, I would say in the next 2 weeks,
Mike, Pitt's on board, with this, so.
so if it's possible in the next 2 weeks to
MOU.
put this in the form of a resolution, speak to the comptroller about his opinion on where the funding comes from, and in a perfect world, have a memorandum to the collective bargaining agreement, and then we get it done.
Yeah, that's doable.
Okay.
That's doable.
I have no
So
objection.
I guess the one question is, do you have a person in mind for groundskeeper too?
I do, one of
Okay.
the current employees.
All right.
Okay.
So then theoretically, this could take effect at the next meeting if we have everything.
Yes.
Does that work for you, Steve?
Yeah.
Okay.
We were back at the pass card system. I did my best during the latter part of the year to encumber funds for the projects that were in progress, and apparently missed this one. Frederick said that we don't have the funding in the budget for this to be paid.
Our last discussion, I think a requirement of the board was placed to Mr. Haran to get a policy, correct?
So we had some back and forth, and I think we were going to work with Craig for my take, because I don't really quite understand how the system works. I mean, I had kind of chimed in what I thought my thoughts were, but as far as, you know, implementing who, what, where, and I know Steve had made some comments. I think we should probably address some of those issues in executive session because of the security nature of that.
So you're talking about addressing the permissions in executive
Correct.
session? Okay, so aside from the permissions, this is basically an AMEG system, right? It's like a key control, key card control?
It's a
Key fob is a fob
Key
system?
fob.
Okay. I know there have been some discussion about this in an effort to try to improve accountability on access, because there's keys out all over the place from the hard keys. I know that there have been discussion. I know that I don't believe we had reached consensus.
That's correct.
No consensus.
That said, has this work been done?
Yeah, the system's installed and ready to go. Apparently, there was some confusion on what was and wasn't approved.
So there's some key questions I think need to be asked. Number one, who authorized it, right, to do it? Because again,
Well, again, I recall a discussion in executive session, and again,
That's not the same as a
I spoke to you
resolution.
previously. You want the answer to the question?
sure, go ahead.
I spoke to you previously and stated that my emails with the vendor to go forward with the installation started the day after the July 17th meeting. And those same emails started inside the supervisor's office to the staff, advising them of what we were going to do that same day. So it appears, you know, even though, you know, executive session discussion, because it was a security issue, and there are no records of the discussion in executive session, but everything points at it being approved at that night, and I can assure you that I don't do work around here without approval.
Typically, you need a resolution or a motion of some sort to approve
The
the
amounts
funds.
fell underneath the requirement for a resolution, and I was given the go-ahead.
Okay, you said that department heads were notified of this? Was that by email?
Yes,
Did we get copied on the email?
I'm not aware, you know,
Can you
I
forward
didn't
that?
send the email out, so I don't know who was on the email. This
But
is what
you
I,
saw the email.
excuse me?
Did you see the
I did
email?
not.
You
It
did
came-
not see the email. Okay.
And we didn't encumber any of the funds at all?
No.
So what's interesting here is, as I look at the PO and voucher that's dated December 27th, 22, which tells me it probably should have been an encumbrance.
Which is what, that's what the
Excuse me.
resolution is.
Oh, okay, so it's last year's money. The intent, and I understand the point here clearly from my fellow board members. I don't think that there was any intent here to go around the board. Obviously, it looks like it did happen. Unfortunately, we have an invoice, voucher, and PO in front of us here for an amount of money that's dated from '22. So is there a resolution, Jim, that's here?
Yeah, there is.
So what is your take on this, Jim?
So the resolution is
46.
dash 46. You know, I mean, the issue is that, you know, it was in 2022, so, you know, it is appropriate to pay it out of last year's funds. It is below the, you know, it doesn't require competitive bidding.
Right.
And in speaking to Steve, I believe he had gotten 2 quotes. So, you know, complied with the procurement system, at least to that respect. You know, the only thing, frankly, if there was a purchase order in place, you know, it would have been, that would have been
Enough to
the
encumber it.
ability to encumber
Sure.
the funds in 2022.
Right, we could have technically encumbered, it doesn't matter anyway, because the money's there in fund
Right.
balance, but the point is, this technically is a 2022 expense, and it would be coming out of B fund balance, which we have more B fund balance, correct me if I'm wrong, than A fund balance, so I don't see a real major impact here. I see a matter of principle, which I agree with you. I think there was a level of miscommunication here, and I actually heard Steve just say it, where it was under the 15,000. So just to clarify, under 15,000 doesn't mean it doesn't need a resolution. That means that it's under the procurement amount, correct?
Well, so with respect to resolution, I mean, typically, so the issue is, if there's money budgeted for a purchase, the town board does not have to approve it so long as there's money budgeted.
Right, but
The issue in this case.
it wasn't appropriated
was there was no
specifically for this.
Right, there was no appropriation here. And and that's the reason why you do the PO number, two reasons. One, you confirm before you make the purchase that there's budgeted funds, and then secondly, should the project not be completed in the current fiscal year, the controller then has the ability to encumber those funds for, when the bill comes in the next year. So the purchase order does those two things. And once if you had submitted a purchase order, then the controller would have said, at that point in time, what line does, part of the thing you put on the purchase order is, what line do these funds come from? Check to see. And then also what happens at that time is the controller then would encumber those funds in that line so that the next purchase that comes out of that line, they're aware that, a certain amount of funds have been committed from that line, so you can't double commit.
So in order for the controller to encumber those funds, they would still need a resolution to do that, correct?
No.
He can just do it?
That's what the PO does. Assuming the funds are there, right? What this resolution does, all this resolution does basically is retroactively retroactively funding the line. So that this
But you're doing a transfer from a B fund balance.
Right.
Right. In this case, you're right, Al. Let me say it this way. So theoretically, the director or supervisor of buildings and grounds has the ability to spend money up to X amount within his budget if it's appropriated already during the budget process by the town board.
Right.
This particular specific item was not appropriated
Right.
by title within. And I will say, I remember having conversations, and just for full transparency, folks, we're talking about a security system in the town hall. So some of these things, we can't be specific about some of the modules here, or else we're going to breach our own security. But some of the aspects of this were discussed in town hall, the options, this, that, this over here, that door, this kind of thing. So yes, we had those discussions with respect to what it would contain. There are further discussions that need to occur for permissions to be granted and how that process is going to work. Without belaboring the point, it's Custom Security Systems. It's Mike Wachowski, who we have a relationship with here in the town hall. I actually texted him a little while ago to confirm that this was, is this work done? Yeah, this work is done, and he was under the impression that everything was approved, which I could say we've discussed many of these aspects within executive session. That's why it's not on the record. That said, the total amount is $14,892. There is a resolution here indicating that it was a purchase that was made in 2022, which requires payment in 2023, thereby coming from unassigned B fund balance. I don't agree with the process that occurred here. I don't think anyone did anything intentional, but I think we need to tighten up our internal controls with respect to any purchases, just to make sure we have our ducks in a row so something like this doesn't inadvertently happen again. And just to get this off the floor, I'm going to move that we authorize it.
I just want to say that best practices, business practices were not followed, and this should not have happened. In a private industry, this would never have flown. This would never be acceptable. There's procedures to be followed, and this board needs to be kept informed. That's all I'm going to say. And right now, this whole thing is on hold.
Well, I got a motion on the floor.
Right, but it's been installed, but it's not operational right now.
And
I just want to make sure that's clear.
If somebody makes a second, I just clarify.
I'll second.
All right, so just, I agree with the councilwoman. So if we pay for this evening, we don't move forward with initiating the aspects of this system until all of the parameters are
Discussed.
are authorized and agreed upon with
Yes.
the town board.
Now, I definitely believe that the vendor needs to be paid. He
Yeah, no,
performed a service.
Especially when
and
the work
it's
was
good.
done in December.
Exactly. So,
So
Thank
we have
you.
a motion and second. All in favor?
Aye.
Subject to, what the conditions are. All in favor?
Aye.
Nay.
Nays or abstentions?
No.
Okay, seeing none, motion passed.
Councilman Neal,
Aye.
Councilwoman Tina.
Yes, I agree to pay the vendor, but not to implement this right now.
No.
Casella,
No.
and Supervisor.
Yes.
All right, motion.
Thank you.
At the last meeting that was a full business meeting, I had discussed the conversion of the streetlights at Robinson Lane to LED. That was approved contingent on my supplying you with a statement. I did that. Some questions arose as to whether my statement was acceptable, and in light of the discussion that we just had, I have not moved forward with this until I get the town board approval to move forward. I have estimated the cost of materials to be $31.34, and that is by advertised pricing that I found on the internet, and we will do the work in-house. And I don't, I would need to have that money appropriated because it would clean out the Robinson Lane line.
So this is, just to clarify, this is LED conversion on a field, or is this on?
No, these street lights for the
Streetlights.
driveway.
So there's about 17 of the 20 that are out right
19,
now,
yeah.
so they have to.
Oh, really?
Yeah.
Oh, wow. Okay, I didn't know that.
So what we're trying to do is get all of them on LED.
Do we have any incentives from Central Hudson in any way to do this? Sometimes they offer incentives.
I've tried that route several times. It goes back and forth depending on what, the programs come and go.
Have you talked with Carrie, our representative?
Carrie Pratt?
Yeah, I'll call her up then
Yeah.
tomorrow.
So it might, they may offer incentives, but the bottom line is opening day is what?
April 15th.
Yeah, so we got to have, well,
Is this going to be done by then?
no, we need to make sure there's appropriate lighting out there for safety purposes.
So you have line item 7110-401B, that's Robinson Lane. You have $4,000 in that line.
Yeah, but I think that's been, I don't think that's an accurate number at this point.
That's what I got from Frederick probably about a week ago.
Okay, well, and I guess that is the number, and this will deplete it, pretty close to full.
But you have the money in the budget for
Aware of
it.
that before I went forward with the project.
Yeah, I would get the pricing and put it on paper, make a resolution.
Well, this is the pricing here, and the more we delay this, the longer it's going to take.
So he has the paperwork, and I'm going to make a motion that we approve the $3,134 for the LED lights.
I second it.
Okay, no problem.
Motion and second, all in favor? Aye. Any nays or abstentions? Seeing none, motion
Is
passed.
there any way you can expedite this?
I'll do my best. I don't know
Keep us
how long it's
informed.
going to take for the parts to come at
All
this
right, but
point,
keep us
But I tried
informed.
to get this going back in February.
I understand that, Steve, but keep us informed on how it goes.
So you should have about $800 left in that line. And
Yes.
let me just say this, if there's anything else that needs to be addressed with respect to safety out there, don't hesitate to let us know. We will move money for the purposes of safety.
Correct.
Now, do you want to bring up your point now?
Which one?
About the Altice?
The Wi-Fi?
Huh?
You mean the Wi-Fi?
Yeah.
Yeah, I can do that now, so certainly.
Steve here.
All right, since we're here, just pass that down. So, Steve, what we're going to talk about right now, since you're talking about Robinson Lane, is the Wi-Fi out of Robinson Lane. We had an excellent conversation today with Altice. It was myself, Jeff Tomlins. It was a number of other folks from Altice, and what we were able to come up with is a terrific solution. So they're actually going to pay for the coax cable. They're going to pay for the box. We've got a number of folks that are going to donate various services. We have Hopewell Septic. They're going to be able to buy the conduit, so we need about 1,300 feet of conduit. It's 10 grand. They're going to be able to do the excavation. Another 7,500, although some of that will be donated back to us, so free labor. And then we have some bill here from ITC, which is going to do all of the router, modem work, et cetera. All this would cost us is $25,000. We would have Wi-Fi out there, and they can probably do it in the next month or so, assuming that the conduit is available. It's going to probably be either 2-inch or 3-inch to structure 80, which is the heavy-duty stuff, so if cars and trucks run over that. And Altice has been very, very cooperative with us to help us out, and if they can do more, they will. So what I like to do tonight is to try to get this thing moving forward, is I'd like to ask the board, and I've talked to Jim Horan already about this, is that the money could come from Parkland Trust. Right now, the totals that we see now are about $25,000. Again, this would come out of Parkland Trust. We have roughly $398,000 in Parkland Trust. So $25,000 would be, small compared to the balance that we have there today. I think it's a great opportunity for us. We've been trying to get out there. Challenger Field, I will tell you, is going to have a jamboree this year, so it's important for us to get that out there. So looks like it's a go, and so I'd like to ask the board if for a motion to approve up to $25,000 to be moved out of Parkland Trust to get the ball rolling on, again, the conduit, the excavation. We have somebody who's going to do the marking out for us, and we have the buy-in from Altice to hook us up, and we're looking for them to run the cable as well.
Second it.
Any questions I can ask for answer from the board, things you might want to
I'd
know?
just like to thank my council colleague for all his hard work in getting this done. Thank you,
As Councilman
Councilman.
Beal always says, there's no service out there. There's,
That's right.
It's about safety is what it's
That's right.
about. Roger Connor, who also has been heavily involved with Altice, thanks to the supervisor helping us out with Roger and getting that out there as well. But Roger's the one who set up the meeting for today to help us make this happen. So again, a great thing if we can get that out there, and hopefully in the future when they decide to do tournaments, we missed out this past year because we didn't have Wi-Fi out there, but we'll also have live streamline. They'll also be able to have a credit card available, so hopefully that'll all be part of the service that's provided as we move forward with this.
So we have a motion and second. All in favor?
Aye.
Aye.
Well, I just had a question here.
Sure.
So this is going to provide Wi-Fi to the whole property?
Yes.
Okay. And is this is wireless internet service, so this is going to allow for people to access Wi-Fi out there, or what is the end
Yes,
game here?
that is correct.
So it's basically an open Wi-Fi system for folks to be able to...
Yeah, so it'll cover about 3,000 feet. The actual setup is going to be on top of the store. So you have the antennas on top of the store. You have all the equipment inside the store, and that'll cover fields all the way out to R4. So we've already checked that. It's about 1,000, 1,200 feet, so it's well within the range that ITC said that this will cover.
All right, so this is going to allow for credit card use. This is going to allow for, in the snack bar, is there any other need for Wi-Fi in the snack bar?
Emergencies?
Well, I'm not sure for emergencies. I mean, unless you're using voice over IP, it's not cell service, so you're going to have Wi-Fi service. So how can we utilize the Wi-Fi service to allow people to contact emergency services? That's going to be the question, because unless you have a voice over IP function, you're not going to necessarily have great cell service out there because of this initiative.
Well, what they said was by putting the antennas out there for the units that it'll have great Wi-Fi service out there.
Right, you're going to have Wi-Fi service, so you're going to have the ability to connect to the internet.
I mean, theoretically, you could put a voice over IP in the building.
You could put a voice over IP phone.
Right.
Well, with that, can't you put a Optum hotspot out there?
You could, but
It's the same issue.
right, so I think I'll support this, but I think, is this under the Altice, is this under any existing contracts?
No, it's not, and that's the issue.
We don't have.
All right, so what I would say is we should look at, since we don't have a landline out there anymore, and the cell phone is spotty, I think a redundancy would be a voice over IP phone at the snack bar, or anywhere else out there, so that if you can't get cell service, you can use that existing phone to call 911. And then when you have a voice over IP phone on a system like this, you have to make sure that the address is properly programmed, because we have folks right now that move to Florida and call 911 on their voice over IP, and their address comes up as, 25 Eck Road when they're down in Fort Lauderdale, because the IP is what identifies the location. So that said,
I believe the town hall system is voice over IP, so.
Okay, so if we can make sure that we have that as also as an option that would ride on this existing infrastructure, and I'll support this.
Okay.
Okay. So we have a motion and second. All in favor? Aye. Any nays or abstentions? Seeing none, the motion passed.
If I could make a suggestion.
Sure.
At some point, the line is going to have to cross the driveway, and we've got brand-new pavement out there. If I could recommend a horizontal drill rather than cutting the pavement.
Yeah, so the intent is to take it from the telephone pole that's within inside the Robinson Lane facilities, cut it, not on Robinson Lane, because we talked to Mike Sheehan, cut a diagonal going across, right, because they'll be able to lay the pipe that way. And Mike said if you needed help or whatever, when asphalt comes out, he'd be more than willing to help you do the repair, because again, you're right, we just did have that whole thing
And a
paved.
horizontal drill would eliminate the need to cut the pavement. And I don't know, that the expense is a whole lot more than cutting the pavement and
Okay.
repairing it.
Something to look in, okay. Thank you.
That's what I have on the agenda here for me.
Anybody have any other questions for Steve? Al?
Yeah,
Actually, I do.
Yeah, sure.
On the west side sidewalk, can you take a look at it? Because there's a major crack that needs to be filled before somebody falls. It's pretty deep. Thank you.
Also, Al, for opening day on April 15th, which this will be the first opening day, I have a child that's actually playing in my 17 years of attending opening day. Please let the Little League know that I will be happy to provide them with a sound system so we don't have to go through what we went
they
through
did
last year. I will bring the sound system.
I think they bought a new system.
Okay,
so-
I'll bring one too.
But please have one.
Because that was a little painful last year. And we have the resources to do it, so let them know.
Thank you for your offer. I'll pass that along to Jeff and team. See, just a couple updates on some of the things you're working on. I know the tennis court resurfacing is going to start pretty soon over at Marks Field, correct? The next month or two?
I have not had any contact from the company. I reached out to them when the job was approved and have not heard back from. We reached out to see that we were on their schedule and never got any response from them.
Can you reach out to them again? 'Cause I saw your note that said it's approved and they got notification, but let's just make sure they stay on top of that. Have you had a chance to take a look at the paving costs for Regency Park? I know you said you were going to talk to Clove.
I haven't had an appointment. I've reached out to them and I haven't gotten an appointment with him yet.
Yeah, I just want to get an estimate. I'm sure like the supervisor wants to get an estimate on the parking lot as well, so I want to look at that too. As you saw the note from our soccer friends, the geese out there at Regency, any solutions we can do?
I'm working with him and taking care of it as best we can, before he needs that stuff out there. But we're on it.
Couple more. Carnorth admin roof. Do we need to do something with that?
Yes.
Probably need to make a repair on it.
Best condition.
So can you get an estimate for us out there so we can get that
It
repaired?
requires a replacement.
So there is a replacement?
The way it keeps, tearing off, I believe.
Which, you
The
said
Conrath
Admin building?
The one with
The faulty roof,
Oh, I
Jeff.
thought you said asphalt.
No.
No. Carnorth admin
Yeah,
building.
the roof at the admin building needs full replacement.
Okay. Do you have an estimate? Can you get us an estimate? It's got to be done. That's one.
I've come in with a ballpark number.
Okay.
It's above the requirement. It would have to go to be a public works contract. So there's no point in me getting estimates because they aren't. The one I already got puts it into the public contract area, which means it's going to have to be engineered and go through the attorney to be contracted. I did find out that the roofing company that we use is Vanguard, who did the roof here and has done the emergency repairs down there, is a member of a purchasing co-op that's approved by New York State and would eliminate the need then for us to go out to a public works contract.
Who did the repair job down there, though? That
Originally?
Original.
Wasn't it
They're bankrupt.
Was repair, just tell me a little bit more about what you're asking here.
correct me if I'm wrong.
Original roof?
Yeah, wasn't there a contractor that
That was part
came
of the
in?
renovation of the building.
Right.
And that company apparently is dissolved.
It just blows my mind that this continues to happen. We have a contractor come in, do the roof, the
Right.
company goes out of business, and then the roof falls off.
And there's no recourse on it.
Right.
Low
And
price
that's where
bidding.
we're at, but we still have a roof that's coming off the
So could you
building.
could you just make your point to Jim again about Vanguard and being because we
Right.
might be able to use them.
So, no, it's another one, I don't have the name in front of
They're
me,
on a
but I did
co-op.
look it up, and it is a purchasing co-op that is approved by the state.
Yeah, I mean, we've used Vanguard, on a lot of buildings.
Right.
So then, if that's the case, can we just get a quote from them?
That's exactly what I'm looking to do.
Right, so, assume, what's the ballpark number like?
He had expressed to budget 50,000.
Okay, so what we do is, you get an estimate from them, and then, you
Right.
make an appropriation, it's gonna be from, Parkland Trust or something else.
Well, didn't we look at insurance also? Because wasn't there storm-related damage or something that,
Yeah, that's already been repaired. That tornado or whatever it was that came through there, the storm
Microburst.
blast,
Right.
knocked a couple trees onto the brand-new roof, and they did do the repairs to that. But this is on the other side of the building.
why don't we just get a quote from Vanguard and move on this? 'Cause
Exactly, that's what I want to do.
the roof is, we could sit here all night and talk about the fact that, again, a vendor went out of business, but
So
let's just get a quote.
Can you prepare a resolution for Steve once he gets you the estimates so we can approve it?
Yeah, I mean, if
April
he
10th?
gets me the info, I can,
Thank you, Jim.
Please.
we'll do it for the.
One last one for you. I apologize. So the cars out here, the town parking lot, the blue car and the one next to it,
You was talking about specific vehicles?
yeah, it's two specific vehicles right outside here of town, right in the town hall parking lot, actually.
The Impala.
Yeah.
The Impala, is it gone?
Yeah.
Okay. What about the other one? There was actually two vehicles there?
They're at my shop, and
Okay.
I plan to put them out to surplus.
Okay.
I've been waiting for the market to come back,
Okay,
so we can get more money for them. I've cleaned them up, got them in running condition to where, I can show
You can sell 'em now.
that they start and drive.
perfect.
And then we'll sell them. But to have sold them when we pulled them off the road, you wouldn't have gotten anything for them.
Okay, very good.
I can't imagine that
Thank you.
Impala's worth anything.
Yeah, I'm not expecting a lot from it because of
parts,
its age.
probably.
But, 10
Your
years
best.
ago, you gotten big money for it because the tax.
Even 2 years ago.
It's got to be a 2005 or 6, though. I mean,
2005, I believe.
Ruggiero was driving around that
I
thing.
think you were on the board back then.
2007, I was. It was being used back then.
I was kidding. I'm good. Thank you, Steve.
Thank you, Steve.
That's it.
Yep. Thanks. You ready for Craig?
Yeah, let's get this
Okay.
over.
Craig?
Craig, I didn't even see you back there, and
Yeah.
Steve was blocking you, and I'm sitting here, I'm talking about voice over IP, and you're in the room. Sorry. I hope I made sense.
See you guys.
Thank you. Yeah, good to see you. How are you?
What a night.
It's been a while.
Thank you for coming, Craig.
No, thank you. No problem. So I was asked to come here to discuss a recommendation that I had submitted a couple months ago. This isn't anything that has to be done. This is just a recommendation. Do you want me to summarize, or, yeah? Okay. So the town pays $2,649 a year for the town email service, okay? That's in the Microsoft Office 365 cloud. It's a government cloud, which means the data centers are US-based. And that renewal happens every June, okay? And it's an annual renewal. My recommendation was you guys may want to start considering upgrading the license from email only to the full Microsoft Office 365 suite to replace the almost antiquated Office software that the computer users here are using, but also it's going to give you a lot of new collaboration tools that you may be able to take advantage of, like Teams, for example. I know one problem I have with my email box is I get inundated with emails, and it's very easy to overlook, You know, I think we all suffer from that now. Like, we have this email fatigue where everybody just emails. One of the things Teams can do is that can kind of refine, like, you can have a group just for you guys to collaborate on things that, I mean, I overheard a lot of things tonight. Communication is obviously really important. Nothing needs to be overlooked, otherwise problems arise, but something like that could help with situations like that, right? It could also replace your Zoom account, which I know you adopted after COVID for video conferencing, so you can save a little money there. But you're also going to get, every time they release a big feature release with the Office software, you're going to get that with the
Automatically.
subscription. Yeah. And one last thing that you'll get with it is the ability to put legal hold on your mailboxes. So if there's an issue, let's say with a town employee, I don't know what you guys go through, but I'll have the ability to put a legal hold on mailboxes, so that way it'll protect email data or from being deleted by the user to try to cover up anything, you know, things like of that nature. So it comes with a lot of little things like that, right? And my job for you guys is to kind of keep you in the now and modernize you, right? This isn't something that has to be done. This is, you know, I don't want you guys to think this is necessarily you have to do this. You don't. I just recommend it, and it's a good time to start thinking about it because the renewal is coming up in June. So,
Greg, does that give every user the ability to use the whole suite of Office projects?
on 5 devices. Yes, it does, and it can do that for each user on 5 devices. So everybody in Town Hall pretty much has 2 devices already. They each have a computer and they each have a phone, right? So that's 2 devices already. Some of you have 3. You have a laptop, a computer, and a phone, okay? What this solution will do is enable any user that is licensed for it to access any of their documents on any of their devices. Building department, I know a lot of them are out of the building a lot on inspections or have you. They can certainly take advantage of that added, you know, mobility feature. I'm sure the 5 of you can. You know, I know the 4 of you aren't here a lot during the day, but you still have to do your town board duties, and having a capability like that may be beneficial for you. So that's kind of how I've been thinking about it, and that's why I wanted to present it and just recommend it now. Give you guys some time to think about it. And
I think it's a good idea to be proactive and just stay ahead of the curve and have everybody trained, and instead of waiting.
Yeah.
I think it's a good opportunity, and thank you. But
Yeah,
I really,
no problem.
I think we should pursue this. I really do.
What's
As a town.
you said $2,600 per year?
Excuse me.
Yeah, so here's the thing. You guys have 61 mailboxes.
Okay.
Not every one of those users needs this full suite of products, okay? You have a lot of staff members like highway workers, you know, some of the guys that work for Steve, that they don't touch a computer, so they don't need this, okay? So they could stay on the email-only license, and that's not going to... My focus was to upgrade anybody that uses a computer, or anybody that, you know, uses a phone but needs some of that extra capability. So out of the 61 users, I think there is about 33 that have computers, and that includes
us.
You, right? So you know, and I did email the quote from Planet Technologies. They're your government vendor that gives you this licensing at government pricing. You know, you don't have to. There's no competitive bid for that. It's a cross the line. You know. So anyway, I did email that to you. I can resend it. But to answer Mr. Beal's question, if you were to go with this in June, the renewal would be $9,318.24.
Go ahead.
No, I just want to say, that's just me estimating who would benefit from this license, but you, of course, can review the user list and say, well, this person, we don't need this person to have or this person to have it, and you can correct me, but that was my...
Does that include the judges in the judicial system?
Good question. They actually have it through the NY court system.
Okay, so we don't have to worry
So
about
you
that.
don't have to worry about them. And
Okay.
I excluded them from.
Thank you.
From the licensing fee because of that.
They have that, okay.
They do have
Perfect.
capability. Their stuff has to be, I think, legally
Okay.
segregated from anything that happens here.
Perfect, thank you.
And the court system now is switched over to Teams.
Yeah, so.
They
Right,
no
which
longer
is-
use Zoom.
Good segue. So, you know, Craig's been very proactive with respect to cybersecurity, obviously. It's a big concern. You know, I deal with it my day job. We host the Hudson Valley Cyber Summit right here at Marist College. You know, every year there are concerns with respect to governments and their cybersecurity. The county has recently switched over to Microsoft 365. The highest levels of security protection exist. We use Teams every single day, not only just for meetings, but for the purposes of maintaining files for different projects. I mean, I could see us using Teams so that we could be sitting right here and pull the town board rules right up. You know, there it is. You know, we could have a cloud-based location for everything that we're doing. God forbid we have another situation where we can't meet in public. We would have a continuity plan already on a common platform. And I think that, yes, it's additional cost. However, I think that with respect to the security provisions, the access to those platforms, PowerPoint, Microsoft Word, Excel, you know, the 5 core Microsoft programs, I think it's going to allow for interoperability for each of us, a little bit safer for us to share files back and forth and not have to worry about emailing everything. So I would be willing to support this. We have some time to find, to increase the appropriation, but I do think there's value in moving toward the 365 cloud-based environment. I think it's a better way to go overall.
Thank you. I totally agree, and I appreciate you coming back to us after we had to cancel the last time and
No problem.
broadening our viewpoint on this.
No,
Well,
yeah.
major corporations are using this already. I use it in my private sector in
Yeah,
my
so
job.
you're
And
familiar- yeah,
I'm
you're
very
familiar
familiar
with it. Yeah.
with the pros of this. It's just fantastic.
Yeah.
And to be able to receive the upgrades when they happen in real time is remarkable. It's really a great tool, and I think the town will benefit from it.
Okay.
So,
Great.
thank you.
So, all right, I'll leave it at that.
Okay.
And then we have until June, you know, to make a decision. So I guess you'll circle back to me or with questions, or I'll just touch base if I don't hear from you, type of thing.
I think just,
Yes, please, thank you.
you
For
just
us
do it.
who
Let's just do
are,
it.
Technically challenged.
I'll reach out to you.
Yeah.
My biggest problem is toggling between team accounts.
Well,
It's a little,
that is a challenge. We dealt with this during COVID because it would default to my county email,
Yes.
right? And then I had to figure out how to
you have to go in and
log
change
out.
it.
Switch.
Yes. you
That's
have
why I
to
think,
switch.
and I'll just say this, I think we should have unique devices for our town
Correct.
work. We'll talk about that.
Sure.
Because it's difficult for me, I mean, I have a few different jobs, right? It's difficult to do when you have multiple Microsoft 365s,
Account-
right? For each
accounts,
thing. So I got
right.
it for I got it for the county, I got it for the business, I got it for the radio station, right? But then you're sitting here trying, how come I can't link
Who
up?
am I?
Then we finally figured it out during COVID that you have to
Who
am
I?
log out of your
Right.
most recent use. So I think if we could look at unique hardware also for board members, because everyone has a desktop here in this building. We don't have that ability to come into a desktop, with the exception of the supervisor. I think we can't be sharing, and also for, Jim, for discovery purposes and everything like that, our town work should be on a town computer, to keep it separate from personal use. It's a cleaner, I think it's more secure, and this might be a good segue if we go into this new Microsoft 365 platform.
Yes.
But I think we should move ahead
Yeah.
and purchase the 365 Microsoft
I agree.
package.
Agreed.
Jim, what do I have to do? What do we have to do to get
Put
that
together a
moving?
resolution.
I don't really want to wait till
I mean,
June.
the only thing you'd have to do at some point in time is make is there money in the line, or is there?
That's a good question. I don't know.
I don't believe there is, but we can check. And
We did
can
add
get the
some money this
resolution.
year. We did add money, though, to his budget this year, so I don't know if that's
Yeah, we
included
did.
in it or
We
not, but we
added.
did add money
I mean,
year over year.
if there's money in the line, then it's just a matter of
No, we'll
the
check
purchase
that.
order.
Yeah.
Okay, so let me just clarify. If you didn't want to wait till June, okay?
We
Then,
get a discount?
well, there'll be a prorate, because then you're still on the tail end of last term, right? So if you wanted to upgrade before June, you could do that. It would just be prorated. So you would pay, the licenses are $20.24 per user. So you would just be paying that per user for April and May, for 2 months.
Okay.
See what I mean? And then in June, you would renew for the full year. So I can just update this.
What do you recommend? You tell
Well,
us.
the recommendation is really, if you want to get going on this right away,
I think it's important to
then
move
I
forward.
will get this quote updated from Planet Technologies. I'll resubmit it to you, and then you, Mr. Haran or whoever, just say when to pull the trigger, and I'll make it happen.
Perfect.
And then regarding the devices, you let me know what you need me to do on that end, if you want me to get you some quotes, or if you want to tell me what you're looking for. I don't know if you're looking for tablets. Or
No.
We should.
We tried that.
We tried that, and it
We
didn't
tried that. I mean, no offense on those
No.
Chromebooks, but,
No.
and I understand people got together and did what they had to do to get us Chromebooks last minute for COVID. I appreciate it. Thank you so much for doing that. However, in retrospect, when we're trying to do remote meetings and we're trying to do two things at once, and we pull up that file while we're on, it doesn't work on a tablet. I'm
I
sorry.
agree. I
So
agree.
if you could just take a look and give us some recommendations
Right.
on laptops, okay, that would work, optimally with Microsoft 365, purely for town business only. Send us some information on that. That's going to be something we're going to need to take a look
Yes.
at also.
Great.
That would be perfect.
5, yeah.
Yeah.
The only question I have is screen size. Typically with you can go 13-inch, 14-inch, or 15-inch.
I would just say, look at what you think best would work for us. I mean, I got a 13-inch Mac, but that doesn't mean that's going to work for Angela. So whatever you think is
I'll
is
get
most
you a quote
appropriate.
for one of each.
Yeah,
That would
let's
be
take a look at it.
really good.
How about that? And then you can choose your size.
Thank
I mean,
you.
as the days go by, I
Thank
see
you.
myself getting closer and closer.
Yes.
Yeah.
Me too.
Not long till I got a phone.
But I appreciate it. Thank you. I think we appreciate it. I think we learned a lot. So
Okay.
sorry for the late hour, but
No,
thank
it
you.
was, I needed some excitement, so I'm glad I got it out of my house.
And PC, by the way, PC,
Yeah.
not Mac, PC.
Yeah, no, not Mac.
Because Microsoft 365, correct me if I'm wrong, works cleaner on PCs, correct?
Yes.
Yes.
Oh, yes.
Yeah, Macs no.
I'm a big fan of the Surface Pro.
They're nice.
They're nice.
No, they are pretty nice.
What, the Surface?
Yeah.
Well,
I mean, there's a Surface laptop. And
we'll let our professional
You will let us
give
know.
us some options,
I'll give you options.
just not the Chromebook, whatever it
No,
is.
no, that,
I don't think I've
you.
turned it on since our last meeting.
We actually should
You can
probably
donate
give
it to the
those to
school
the
good. You could.
seniors so they could play with them.
Good luck.
That's true.
Really, I'm serious. We should just,
Sure, you can have mine.
thank you.
All right.
Thank you.
Good seeing you.
Okay, thanks,
Same
Craig.
here.
Take
Thank
care.
you.
Thank you, Craig.
Okay, next item, rules change proposal.
Perfect timing, huh?
9 o'clock.
So let me just say this, I didn't want to interject before. I don't think the intent of, because I'm attached to this discussion item too, although I didn't put this narrative in here. I don't think that Councilman Casella's intent was to stop meetings at 9 p.m. I think the intent was to try to limit the discussion items. Barbara, when we were serving together on the town board, meeting started at 7:30, and we got out of here by 9 or 9:30 most of the time, because we were able to get to Outback before the kitchen closed. Just saying. That hasn't happened in probably 5 years or more. We actually started the meetings earlier here at 7 o'clock so that we could get out earlier, and that did not work. So I think what my intent was to try to limit the number of discussion items, because we've had a number of evenings where we have over 10 discussion items, which just by the nature of the discussion they go on and on and on, and there have been at least a dozen times where we have reached the midnight hour here, which has been a real challenge. What my approach was, and Al had put this on the agenda, but my approach was to take a look at the existing town board rules, right? And to first look at the items that are no longer relevant, because there are some things here that are not even relevant anymore, and to address those. I'm not going to get into that tonight here specifically, but I think a good start is to take this actual document and to make some minor changes to it. That said, I do think we need to make a concerted effort to be done by 10 p.m. I really do, because after 10 p.m., generally, it's dragging on and on and on, and I don't think that folks should be sitting here till 11 o'clock at night to hear the whole meeting. I think that we need to make a concerted effort to try to get this more efficiently accomplished. So within the existing town board rules, I have gone through and just made some bullets here for things that we should consider, okay? Discussion items. Sponsored by, is there a sponsor required for discussion items? Okay. If so, by whom? I'm not looking for answers now. These are just little notes that I took here, right? Things that we need to consider. Limit number of discussion items in one particular evening. A mechanism by which discussion items can be put onto a workshop meeting that could be held at a pre-designated time, whether it be a Saturday morning where we've had very productive Saturday morning meetings here where we can really roll up our sleeves and get into some of the issues specifically. I think that's something there should be a mechanism for within the town board rules. There's always been this, and Barbara, you'll remember this, there's always been this fluid deadline that has occurred with respect to submitting things to the town clerk, right? And I don't think within this existing town board rules that the statement that says the agenda for a regular town board meeting shall be closed at 1 p.m. 5 business days prior to the date of such regular meeting. I don't think that that is accurate or appropriate. And we've been, correct me if I'm wrong, Town Clerk, we've been going with Wednesday prior to the meeting. Is that correct?
No, Thursday.
Thursday.
All right, yeah, so again, so we have to, what's that?
I don't recall a 5-day limit. I believe we always stopped it at
Yeah, we never followed this. My point is we never followed some of this because
So
it
we
didn't make
should
any
have.
sense.
So we have to change it.
So what I'm doing here on this document is I'm just noting these things that we are unable to follow because it doesn't make any sense. This was written before email really was used too. When you go back to the beginning, this was written when things had to be hand-delivered and things had to be in person. So is it Thursday at noon? Is that what we're going with?
I think you're doing 3 o'clock, right?
Right now, it's Thursday at 4 p.m., 3 p.m.
Okay. So we need to come to, not right now, but we need to come to a
Right.
consensus on what works with respect to the agenda closing. This also gets into well, it gets into quorum, which we know. We talk about that. It gets into some of the parliamentary procedure, which I get. It has to get into that. Rules of order. But there are some things in here, I don't want to get into all of this right now because there's some things that are purely grammatical that need to be looked at. But what I like to do is take this document, and this is just from my perspective, take this document and then circulate it amongst the town board members so that we can all see what needs to be addressed. And I think that would be a good start to address some of these discrepancies within the town board rules. And for the folks that don't know what we're talking about, basically the framework of these meetings is established through the rules of the town board, which are adopted at the reorganizational meeting. And I know the last couple meetings, I think we've actually tabled them with the intent to make the changes.
To update them, right.
So I think now's the time to do that. And that's where I stand. Al, I'll yield to you since you were the co-sponsor of the discussion here.
Yeah, so I agree with what you said. Actually, I put number 15 out there thinking of you because you had talked about how meetings were going on for a long time. I used to start at 7:30, be 9:30. So I just put it out there as a statement, hoping that you would pick up on it, what you did tonight. So thank you for clarifying that. As far as town board agenda items out there, real quick, I mean, we're looking for a sponsor. We've been doing a sponsor for quite some time now. We haven't made it official. I think you, actually, Bill, talked about that tonight. And the only other piece, number 14, was to, make sure that we give the town clerk here all the information you need tonight. So as an example, if we decide we're going to do a motion, it's not necessarily something that's in the package today, but it's off the floor. Just make sure you have the necessary paperwork so that, like I gave him for Little League Baseball, so that, they can go ahead and record it properly. So that's all they were for. But again, my intention was not to cut off anybody at 9 o'clock. It was more of a discussion point. Could I have done it, worded it better? Absolutely. You're absolutely correct. I'll give you credit on that. Instead of putting a timeline out there. But again, I just wanted it to be a discussion point, because again, we want to make sure we hear all the residents, what they have to say. So if it takes till 11:30 or 12 o'clock, it takes that long. That's all there is to it. But again, that's more about, talking about, again, how 7:30 to 9:30, you guys are out and talking about discussion points and how we can make things, a little bit shorter, that's all. But again, no intention to harm or keep somebody from not being able to speak at 9 o'clock. If it, like I said, if it goes till 12 o'clock, it goes till 12 o'clock. So that was it.
And it's important that people come to the meetings. Today, we had a good turnout. So if we keep the agenda to a reasonable time, I think people will be more apt to come to the meetings also. I don't think anybody enjoys staying till 10 o'clock at night. And I understand there's times, I get it, that you have to, but we want to keep people interested too, and we want them to come back. So.
And that said, it's not uncommon, because we've done some research on this, it's not uncommon to have a time that regular business should end by. Town of Amherst, which is one of the models we looked at, specifically says 10 p.m. Regular business shall be completed. And not for nothing, but on the floor of Congress, I happened to notice the other day as former County Executive Marcus Molinaro was the Speaker of the House for a day. If you listen to them read the rules of Congress, they actually have a time that all business must stop by, so that people aren't just going on and on and on. So, my point here is not to limit participation, but let's be straight up here. We have to have some sort of ground rules in place, because it is not appropriate for any meeting here to be going past midnight. It's just not appropriate. Not only because people have to get up for work in the morning, but I'm coming in at 12:30 and waking up my 2-year-old coming into the house after midnight. That is just totally ridiculous as far as I'm concerned. So I think that in the interest of the town, if we can improve efficiency by perhaps looking at some of these rules and tightening things up, I think we're going to be better off moving forward. So I will take my edits, and if we had Teams already, I could just put it up in Teams.
There you go.
We don't have Teams yet, but I'll circulate it amongst the town board, and certainly any public that has any input, feel free to reach out.
And these are on the website.
Yeah, that's right.
All of these are on the website, too.
Yeah, I mean, you can
Anybody's
Google
interested,
this
you
right
can
now,
see
and
it.
it'll pop up. It's just that the version
Comments
that's going to
are
pop
welcomed.
up is the old version that not all of it is still applied.
But as you said, Bill, I think the Amherst one is one of the best models out there.
The Amherst one is really comprehensive, almost to the point.
Too much work.
It's almost too comprehensive. I mean, it micromanages every single aspect of the meeting, and I don't think we want to be that tight, because we want to have some flexibility as discussions occur, like tonight. You can't say, okay, well, we have this thing on the agenda, but we have 10 minutes for you all in this room to express your feelings. I don't think that's appropriate.
And
So
that's
we have to
not
have
the
some
intent.
flexibility.
Yep.
Yeah.
And this actually also said, including executive session, which is not on here, it said 11 o'clock. So
Yes,
I originally said that on here, so somehow it got cut off, but that's besides the point.
No, I think your intent when you put this on was the regular business should be done by 9, so that we're not.
Exactly.
I think that's what your intent was. Correct me if I'm wrong.
Yep, no, you're correct.
Okay. And I don't have anything further for tonight, but I think just we are moving forward to try to address this.
Thank you.
I agree, I think. Any other comments, board members, on that one? Okay. Christian?
You wanted to talk about the,
Senior property tax.
Senior property tax, yep.
right, you had the disabled persons exemption and the partial exemption for senior citizens. Not much has happened with these exemptions in a long time. The state has come through with new levels that you're allowed to adopt. Currently, town of Wappingers for the senior citizens exemption, the max amount of money you can make is $32,400 and get an exemption. The new level that the state has allowed is now $58,400. A few places have started to adopt higher levels. Clinton went up to 37.4, Northeast is at 43.4, Town of Poughkeepsie is at 37.4. So you could adopt anywhere in between those numbers. They issue a whole bunch of options with a letter. So you could adopt level D, level F, level G, depending on where you want to go. The school district for Wappinger Central, that's our biggest school district, they raised theirs to 48.4 with a 3-year plan. They're going to go up $5,000 next year, and then $5,000 to the max at 58.4 for 2025. I believe the county, if they haven't done it already, they're going to adopt 43.4 for next year, and then 45.4 for the year after. So they're not going to the max, but they are increasing their limits.
Kristen, do you know what the school's giving as a tax exemption for those amounts? Because that's, as people should know, is the biggest part of their tax bill.
Right. Well, for Wappingers right now, if you make $40,000 or less, you get a 50% exemption, which is the ceiling. You can't get any more than 50%. Okay. So
50% of assessed, what is it, 50% of assessed value?
50% of the assessed value, right. And it slides down to 5% for the $48,399. Technically, anything over that, and you get zero. So you don't get an exemption at all.
So can you also get the senior tax exemption plus either the star or the enhanced star?
Yes, you can have both.
Get
Okay.
both, yeah.
So they're completely different exemptions.
Okay.
So one's paid for by the state, one's
And the
paid
card,
for by
and the card you're referring to that people got is this little mailer here that was sent out?
Correct. That was another caveat to the law that they created this
So if you
year.
guys got
Right.
this-
What does that mean? What does that say?
Well,
So it
I'm
says
sorry,
senior
I'm not
tax
age
exemption.
eligible to receive that.
well,
What
you
does that say?
should have got one.
I'm not either.
We sent one to everybody.
Everybody.
We sent one to everybody, regardless
Yes,
of
it
age.
didn't matter.
Yeah.
So-
So basically, what it does is it says, call your town clerk if you have
Yes.
questions, if you're, it's
Okay.
applicable to
It's
you.
gonna call your town assessor.
That's what it says, so
Your
if you can
town
read the letters
assessor,
down there.
yes.
Sorry, I can't see without my.
So
And
we
you
were,
did a fantastic job, too, answering
Yes.
all the questions.
we got inundated. Those went out around
Yes.
February 1st. and
Yes.
So they're all
It was an
calling you?
explosion in the office.
That's what they're
It was
doing, okay.
unbelievable. So, our
Thank you, State of New York.
So, yes, I think our phones can hold 50 or 70 messages. We were at the max, and we just couldn't answer them fast enough. So,
And this won't be effective, like Bill's did, he had the ambulance and I guess volunteer
Volunteer firefighter exemption.
It's not available till 2025, correct?
it's good, yes, it's going to be for the 2024 roll, which is going to affect
But you won't get
2025 local
2025,
taxes.
right? Okay.
And we
So-
still haven't heard anything from Beacon.
No, although I was going down the list here, and only 3 school districts, to my knowledge, Arlington, Hyde Park, and Wappinger, have done anything with their level. So the fact that Beacon hasn't talked about it is not, they're not an outlier at this point in time. They're part of the majority. So I don't know what a lot of,
That's sad.
well, I don't know what a lot of school districts plan on doing. Wappingers did theirs without even consulting any of these assessors or asking what the impact might be. Because these, like I tell people, these aren't free exemptions, these are pass-throughs. So if you go and give a large amount of seniors exemptions, everyone else has to make up the difference.
Right.
So, you might think, oh, it's really not that much, but it's really going to start to add up. So,
Right, but they've been paying the longest also, though.
yeah, well, that's true. I mean, the whole point is it's an income-based exemption. So if you're a senior citizen age 65 or older, your home is your primary residence, in theory, you no longer have kids in the school district.
Exactly.
And you have a limited income, meaning you're unable to pay your school taxes, then you should be given an exemption.
Yes.
So it's just how high do you want to make that number? Because the higher you make it, the more people who qualify, the less people paying taxes is the more everyone else needs to pay. to make up that
So the bottom line is the tax levy stays the same, it's just moving the P around.
Right, the levy stays the same, but the rate's going to change.
Correct.
I remember a situation, I wasn't here for it, but Joe Ruggiero told me about it, that they had a very low number on the veterans exemption, and it was around 2006 or so before I got here, and they adopted a much higher level, thinking that, oh, this is great, but then when it came time for the tax levy, they said, oh, we did a great job budgeting, we're only looking at a small increase, and then the tax rate went up 7-8% or so, and everybody
Right, to
was,
cover it.
oh, what happened? Well, you went and gave the veterans all this, you went to recognized the veterans and gave this great exemption, but there's at some point in time, you got to pay the piper.
So
So
the school could be significant.
the school, I'm not sure the school knows what path they've led themselves down. They didn't ask me, so.
That's what I want to say, you know, is there a way to calculate fiscal impact? So, you know, we talked about the volunteer firefighter and ambulance worker exemption. You're talking about a handful of people here. I mean, most of the volunteer firefighters in this town don't even own a house. They're,
Right.
you know, either living at home with mommy and daddy or they're renting an apartment. So it's not anywhere near this type of exposure. When you're talking about senior citizens, which are defined as what age now?
65 or older.
Okay, 65 or older across the entire town. Municipalities have gauged this based on different variables. So my question to you is, how do we, in an informed way, determine what the income limit is and what that impact will be on the rest of the town?
Well, I can give you an idea based on the amount of seniors that I currently have filing for the exemption, but I don't know what, if you raise the levels, I don't know who that's going to bring in that's going to all of a sudden qualify, that doesn't qualify now. Because I don't know people's incomes. So there might be,
right, okay,
You
right.
know, we might have 220 senior exemptions right now.
Right.
All right, so
But if we raise the limit to $15,000, we might get 500 or 600.
So what I can
don't
tell
know
you
how
is
many
the
we'd
county
get.
did their
That's hard
assessment.
to-
Right.
The county did their assessment, and it's not a lot of money when you take a look at their actual budget. It's a small percentage. Like you're talking like 1% or less.
So if the town of Poughkeepsie has adopted this and they've determined a specific income limit, right? My question would be, how did they determine that specific income limit?
I think they probably just looked at a number and thought what the best number that fit their.
Yeah, but there should be a methodology. It
I
shouldn't
can
be.
ask the Poughkeepsie assessor. I don't know.
I'd be curious. It should not be arbitrary. There should be a methodology in place,
agreed.
right?
There should be.
The New York State Department of Taxation and Finance might be able to give you some income numbers based on, the filing, because everybody who files, I don't know if they certainly do it by school district, right? Every tax return
Right.
in New York State.
When does the school district become applicable? Is it
It
2024?
starts this year.
So we'll get an idea, because they've got to already do this work ahead of time, correct? So they'll
Right,
have,
with the
they'll have the
mailing of
incomes.
that postcard and the increase in the limits, because the school was at the max before, which was 37.4. Now they've gone to 48.4. They're
my
gonna go
point
up
is,
again and again.
it'll
So-
give you a range of, this is how much the school is going to pass back. Now you have at least a range of, call it $100,000, make it up. And so we would probably be somewhere in that same kind of range, is my point.
Right.
So you have an idea. So somebody's actually going to do the analysis in case we don't get an opportunity to do it until 2025, but we'll have an idea in 2024 what that would be, correct?
Right, well, the school district for this year has seen the big increase, so we can maybe do an analysis of what the school had last year, what the school has this year, and maybe.
That's my point. So you have,
And
if
we
you
can
have data
point to something
points.
similar. I wouldn't recommend going up to the school levels. I mean, those numbers are really high. Obviously, it's up to the town board to decide, not me, but.
I agree, but that gives you a high range if this is where it is from Wampanoag
Right.
Central School.
That's a fair point. Yeah. So, I don't feel comfortable with the fact that the school board did not do an analysis.
Not that I know of. They might have done something, but I can't imagine how they would have
I
done
mean,
it.
I appreciate their efforts, but this is kind of flying blind a little bit here.
Yeah.
So I think the advantage for us is we can see what that impact is based on their tax
Right.
rolls, which come before ours, right?
Correct.
I'll ask the superintendent tomorrow.
I really hope there's some sort of methodology here.
I'll check.
It can't just
I
be
mean, it could be
arbitrary.
a significant impact on the community.
Well, that's my fear, yeah.
And
Just one
as,
question regarding the process. Would a senior citizen have to make an application a separate application for the town
No.
and the school district? I mean, how does that work?
You make one application, and then I determine what your income is based on the law. I put that in the computer, and then it spits out, because I'm able to delineate the levels for the villages, the county, the town, the school districts in the computer. And then we put in your income, it automatically gives you the exemption you deserve, based on the income levels that have been set and what the income that we put in for you is.
And this also
So-
applies to villages?
Villages as well, yes.
How about fire district?
No, not special districts. The only exemption ever to affect a special district is
Right.
the fire district, and that's a brand-new thing.
The village timeline is different than the town for this purpose, or?
Where the village does this roll, let's say the 2022 roll that I completed last year, the village just levied on. So they're always the last one to levy on.
Right.
So
So we as a town have to be mindful, correct me if I'm wrong, on how this could impact village residents versus town residents that are outside the village.
Well, if you live in the town, you're going to get the exemption that everybody else in the town would get.
Correct,
So,
but
because-
does this exemption also apply to their village taxes?
It would, but the village is the one that sets the rate for the village taxes, and we set the rate for the town taxes.
Correct. So with that exemption in place year over year, I could see within the village boundaries, there could be, we'll just say there's some considerations that should be taken prior to.
Absolutely.
Do you know what I'm saying? I mean, there are some unique fiscal challenges occurring within those boundaries. So that said, I appreciate all this information, and I hope that we have some sort of a methodology.
Does this affect Chelsea?
Kristen, if you could get some
the town.
data, that would be really good,
No,
because
just, this will be a townwide.
as
So
Councilman
Chelsea-
Beal said, the
That's in
numbers
the
are
town
really
hall.
arbitrary. The
Doesn't get
income
any
thresholds,
benefit?
people are just pulling them out of the hat.
You have so many choices now. So you could have a low number, you could have some
I just wanna
some
make
places do a
sure
very low
they're-
number, some places have chosen the max. So, I think you
But
pick the
they're
number
in
that
the
you feel
Beacon
most
City
comfortable
School
with.
District.
School district is scary.
They're okay.
I was amazed that they did it, because I just got a memo from them that said, hey, we adopted this. And I would have rather heard from them before they did that, but
Well, they also
That's their
adopted,
business.
surprisingly, and you said this last time, they adopted the volunteer firefighter ambulance worker exemption. There was really no discussion with the fire service, which, listen, I'm glad they did it, but
right.
most school districts are not doing that.
They did a good thing.
So when you have an entity that's rushing into exemptions, that makes me a little nervous.
Yes.
Well, that's why you got 3 jobs.
So I can pay all your taxes.
We're gonna push the P that way.
That's my plan. Work forever.
One note I had about this exemption is, I see that the schools have adopted the highest level, and that's obviously their choice for Wappinger, but, on the town side, I would say if you're a senior citizen, the services you are getting from the town are really similar to the services that a non-senior would be getting. But for
Yeah.
the school district, normally your kids are done at that point in time. So I would say why the town should pick a lower number than the schools, because the seniors aren't using the school services anymore, but the seniors are still getting the same services as everybody else.
Well, not to mention the school taxes themselves
And I was going to say,
could be crippling to a senior citizen
Yes.
on a fixed income.
right, if you look at the disparity, I mean, the school tax rate is, $16 per thousand, a little over that, and ours is a little over $2 per thousand, or
Right.
somewhere around there. So there's a huge disparity. The town has done a great job of budgeting and keeping that rate as low as possible, but for most people, it really doesn't matter, because when the school tax bill comes, it's just massive.
And let me just say this to be fair, the school taxes at $16 per thousand in Wappinger are a lot better than $24 per thousand in other parts of this county.
Yes, I would agree. Much lower than Arlington and Hyde Park and other school districts as well, so. But still, it's a lot of money.
Yeah.
I pay the Wappinger taxes too, the bill comes.
Agreed. We
It's
do
a
our
lot
best.
of money. And then there's also another exemption that kind of mirrors the senior citizens exemption. It's a low-income disabled. So our current level on that is $32,400. So that's also been increased to the same number, that $58,500 or $400 is the max. So Arlington and Wappingers have adopted the same process for that exemption as they did for the senior. So Arlington went right to the max, they're at 58.4. Wappinger Central Schools is doing this, the 48.4, 53.4, then 58.4. Although it's not as widely adopted, Beacon, Dover, Haldane, Pauling, Poughkeepsie, and Weebatuck school districts don't adopt it at all. City of Poughkeepsie, Amenia, Dover, Fishkill, Northeast, Pauling, Pleasant Valley, and Poughkeepsie don't have the exemption as well. And none of the villages have it at all. So it's not as widely adopted as the other one. But again, we do have the ability to raise the limit, so you'd have to think about what you want to do with that one. So, and as far as low-income disabled, we maybe have about 15 of those in the town. So it's not as common. So, but obviously, the higher the number goes, the more people are going to qualify, and the more people have it now are going to save. So you have to weigh your options.
For today, for the seniors who want to apply for that exemption, how do they do that?
They come to my office prior to March 1st, so this year is over, but obviously next year is still available to them. and they give me their tax return from 2 years prior, and then we determine what their income is, because that exemption is based on your gross income. So we have to add up your gross Social Security, pensions, annuities. We take tax-exempt
Whatever, right.
interest as well as taxable interest, dividends, things like that. We don't take any depreciation, so if you happen to own a rental property or something, I have to go back to that income and subtract depreciation from it and then add that back in. So once I come up with a number for your income, then you're good to go. So I need a proof of age as well, just for the record, so.
So Jim, will we need a resolution at some point in time before March 1st of 2024 to approve it?
It would.
Right, I don't think,
Is it by local law or by resolution, do you know?
it's by resolution, I believe. So,
And then the other issue, the other question is, if the town board raises it and sees that it has an outsized impact on changing the tax rate across the board, is there an ability to lower it back?
of course, you can adopt at any point in time what you want to do. So, and there's some caveats that you can pick up too that I think should also be looked at if we increase the level, but that's a topic for when we get there. So, but we have time, and I don't think anything's going to happen in the next few months. It's time for the assessment rolls to come out soon, so most of the assessors are busy, and no one's thinking about exemptions right now, because really, if you do it now, it doesn't take effect till 2024 roll for 25 taxes, but you have them until March 1st to affect that roll. So we have plenty of time to figure this out and come up with something.
Yeah, I think what we want to see is the results of the school district first.
Yeah, we'll run some analysis.
And then when we do that, then we can go ahead and make a resolution, because we'll have a better idea of how it impacts.
Yeah.
Okay.
Christian, before you step down, what are the next steps, key dates for the assessment rolls?
On May 1st is when the tentative roll is going to come out, and then you have grievance day, which is going to be, for Fishkill, it'll be the fourth Tuesday in May, which I believe is the 23rd, and for Wappingers, it'll be the first Tuesday after the fourth Thursday, which is going to be the 25th, I believe. So, and then I have office hours, and I meet with people, so, but the market is still, these values are as of July 1st of 2022, so that's before any real interest rate increases were going on, and the market was still very high.
So what you're saying is?
We're looking at increases. So there's no way around it. So I've been meeting with the state, talking about values and where they want us to be, but, if we don't move our numbers, we're not going to get our 100% of value.
I know.
So,
Because they're always on a one-year lag.
we always pin the date to a time in the past, so it gives you time to analyze what's happening. But from that date of July 1st on, all the sales I have coming in are still significantly higher than the assessments that I have placed on properties. So I don't really see a lot of slowdown in the market yet. Other parts of the country I've been reading about,
Oh, yeah.
places that just went up dramatically, have 200% increases in the last 2 years. Those are starting to see decreases, but we didn't have a market move like that. We went up dramatically, but not 180%, 200%, like Eau Claire, Wisconsin, of all places, went up dramatically. And Omaha, Nebraska, dramatic increases. They're going to see decreases because of how high, the higher you go up, the harder you're going to fall. So
I'll say
market's
this.
up here, but we're not up 180%.
I'll say this again, as I do every year. As assessments go up, tax rates should come down.
Correct.
And that's what happened this year. So I paid less in local taxes, I paid less in school taxes.
As assessments go up, tax rates should come down. It's about levy. You got to look at levy. That's the key, and it's all about spending. So I think we have done a good job as stewards here, and you hear us debate minor expenses here because we try to keep spending down. And you can see our record by looking at our tax rate as compared to other municipalities that are across this county.
Christian, you're set on the review board, right?
Yeah, I think I have one member whose term's expired, and I'm not sure if she wants back on, Cheryl Wallace.
Okay.
I know we contacted her and asked her, and I don't think she's written a letter to us yet saying that whether she wants to be reappointed or not. If not, then we'll have an opening. So we've had some luck finding people lately, so maybe if she wants off, maybe we'll continue to get lucky and find a person. It is nice to have all five people on the board. because
And don't you offer a class too, and it's sometime probably in April, so it gives them time if you get them on board. They need
The
to have
county
it.
offers that class. It's a mandatory class. They offer it Yeah, about April 20th or so,
Okay.
April 15th through 20th, somewhere on there.
So ideally, it'd be good to hear from this person that may not take it,
Yes.
try to find somebody else in.
We were just
meantime.
discussing that today in the
Okay.
office, so we'll
Good.
we'll find her again and ask her what she wants to do. If she
right.
wants off, maybe we have someone interested, I'm not sure. We got a few resumes last time. We can go back to those or put it back on the
do
website,
both,
because that
yeah.
actually brought in a whole bunch of interest all of a sudden, as soon as we
Yeah.
got it on the website, so. But it would be nice to have a five-person board. If someone's sick or can't make it for a reason, you know, the whole worries, we did it one year with three. The whole worry is always, if one of those three gets sick, I only got two, we can't hold a meeting, and that's detrimental. So there's a really bad repercussions for that. So if you got five people, your chances of getting three to the meeting are pretty good.
Yep.
So.
Very good.
Thank you.
All right, I'll let
Thank you.
Thank you.
Appreciate it.
Great. Jim, did you have anything you wanted to talk about E-code?
So there was a proposal from E-Codes to do basically an AI evaluation of our code to look at what sections have been basically obsolete, which we have a lot of. And then it also, according to the proposal, they will recommend changes and, you know, do recodification. And then as part of the process, they also look they look at our local laws and to see if there's any state or federal preemption. I'd be curious to see how the AI mechanism does that, but that is, you know, a lot of our code provisions, some of our code provisions are very old, and they have been preempted for a variety of reasons. So, you know, I know offhand, you know, we've got electrical code provisions that I think are from the 80s. We've got, you know, burning code, I think we updated the burning law, but, you know, so there's a number of you know, older provisions in our code. It also does which I think would be quite helpful, is it does an analysis of various words to see that they're used consistently throughout the code, which we run into a lot, you know, with respect to, I think we've got 3 different definitions for the maximum slope on driveways in various provisions of the code. And, you know, things like, you know, how a building would be described. It may be defined differently in the uniform code section versus the versus the zoning code section, versus maybe the subdivision regulations. So because of the way our codes have been drafted, you know, it's a good chunk of our code. We don't use it on a day-to-day basis, but probably, I would say 50% of our codes, what's in the code book, is holdover from ordinances that the town adopted prior to 1980. And I would think that that's probably about 50% of what's in there. You know, we've got cable franchise provisions that predate the Federal Telecommunications Act. We've got some zoning code provisions that predate recent updates to the Telecommunications Act. It's a relatively inexpensive, I believe it was, I could pull it up, but it's in the neighborhood of about $5,000, I believe $5,000 to do the investigation, and then there's an additional cost if you wanted to do recodification. But I think that would be, to do it, you know, it's General Code Publishing that does it. General Code Publishing, you know, if you ever look at their stuff, they do codes nationwide. So, you know, they've got a lot of experience. It would probably take, you know, an individual, I would say probably on the neighborhood of 40 to 80 hours to do, you know, the review. And even then, it's not going to do the level of review like how is a definition used in one section of the
Right.
code versus the other section of the code.
So general code also owns municity, correct?
Correct.
All right, so until we resolve our municity problems, I'm not spending a dime with general code.
I agree.
And I'm not going to be inserting any artificial intelligence into our town code. That's the last thing we need to be doing at the moment. That's just my personal opinion.
Agree?
I agree. So, thank you, Jim.
Thanks for the research.
Yeah. Okay, very good.
All right.
Okay, next item is Resolution 2023-45, resolution accepting undertaking secured by performance bond for restoration in connection with Old Myers, New York LLC Solar Farm. Barbara, did you want, and gentlemen here have been waiting patiently.
You had to sit here for all that.
All that.
So recently, you granted a rezone for Lightstar, which is a solar farm that's going to work in concert with a farm that we have locally, and they needed to cut down some trees by Friday so that the farmer can actually start putting his crops in. So the planning board approved it, and they had to post a $30,000 performance bond, which they have. And so it's on for the board to approve so they can cut down those trees.
All right, I'll move it.
Second.
Motion and second, all in favor?
Aye.
Aye. Any nays or abstentions? Seeing none, motion passed. Thank you, gentlemen.
Thank you very much. Good night.
Yeah, you too.
Good night.
Very good. Let's see, Resolution 2023-46 we took care of.
Yep.
And the next item is Resolution 2023-47, resolution introducing local law number 3 of the year 2023, amending Chapter 122 of the Code of the Town of Wappinger to update fees and fines. Al and I had talked about it, and I guess, Barbara, you can introduce it, and then we'll have further discussion. Thank you.
I looked at the current fees in the building, planning, and zoning department, and in our enforcement. We have not changed any fees since 2010. A few of the fees I'm looking to increase are mostly on the commercial side and in enforcement. The paper that I just handed you has a couple of amendments that didn't get into the one you have there. And let me just put my glasses on. On page 2, there's one that I starred, and it's for requested site visits by homeowners. If we need to go out, that's one thing, but we have a lot of requests that take our building inspectors sometimes an hour or more. So that's a fee that I'm proposing. The other one that is there in the new one is that we have over 2,100 expired permits. And the problem here is that we don't know if what they built is even safe or they've extended it. So we send out expiration letters monthly. And some people come back and they'll reopen it, but they still won't close it. And some of these go back 10, 15 years. So what I'm proposing, when looking at other towns and how they've handled this, they actually, by law, you have to reopen the permit, so there's the fee to reopen it. The other thing is, I'm saying maybe the first time, it's 10% of the cost, and every 2 years, for the people who won't close it, we just keep increasing it. Some towns actually charge 50% of the cost, plus the cost of the building permit.
So can we offer like an amnesty period? So you open it, you close it, get it done by 2023, because we have over 2,000 open permits, right?
Correct.
So can we offer something like that to try to help you guys get caught up?
I think that would help us a lot, and I think it would be a nice service to your public, residents. Unfortunately, what I find with a lot of the residents, they've hired a contractor, whether it's HVAC, an electrician, a plumber, whatever, and they don't close it out. And a lot of residents are unaware that that's even happening. So when they do get the letter, or it's 2 years later, they were unaware it wasn't closed. And they felt that was part of the service with their contractor.
Right.
But as you heard before, a lot of contractors aren't in business 2 years later. So with these fees, we would put on every homeowner consent that has to be signed before we issue a building permit to let them know that it must be closed out at the end of the job. We would also put it on the building permits, it would be on your website, and if you offered an amnesty and somehow we could get it out to the residents, I think that would be a great service.
And you're still collecting the fees, you're just trying to help
That we have to, it
people.
voids after 2 years.
Sure.
We have to reopen it. So there's that one to look at, and then on page 3,
I just have a quick question on
sure.
page 1. So sorry, the recreation fee. So that's one we talked about leaving it flat from where it is today.
right, and I agree we should leave it, it was just a suggestion
Okay.
on my part, so let's cross that one out.
So that is the $5,000 per unit?
Correct.
Right.
So is that what we're doing right now?
Yes.
That is our current code.
And does the code offer land still as part of that?
I believe the applicant can offer it, but it's at the planning board or the town board's discretion to
Well,
take
If we
it.
accept it, right?
Planning board has to make a determination, in order to charge a recreation fee, the planning board has to make a determination that there is no land on the property that's suitable for recreation purposes.
And then there needs,
That's the law.
and then there needs to be a designation as to what those fees would be
It should
used
be, yeah.
based on the court cases.
Yeah.
So the law sounds to me that it is weighing on the side of donating land over,
Right. I mean, so originally when the law was drafted, there was no fee alternative. That's how we got a lot of these wacky
Right.
parks.
the reason why I'm bringing this up is because we've received so much land over the years.
More, and we're telling them now we don't.
That it's
Right.
gotten to the point where,
Can't do anything with
Can't
it.
even maintain it anymore.
well, not only that, it's land that's
It's
wet,
yeah,
right? And it's land
it's-
that is unusable, and that ends up becoming a challenge for us to maintain, right?
Right.
So I just wanted to make sure that, well, within the guise of the law,
So the question, going back to the issue of supersession, so that's what the town law says, and there's been a lot of litigation on the issue.
Right.
I am not aware of any municipality that has specifically adopted a local law saying, we have enough land, we don't want any more, we only want to charge a fee.
is that legal?
Theoretically, under municipal home rule law, the town may have that ability. If the town wishes to do that, we could request an attorney general's opinion as to whether or not that was permissible.
I don't know if we need to go that far at the moment, but let's just keep this, as you said, let's just keep
Keep it at
this
5.
where it's at.
This money goes in the Parkland Trust.
Right, it's going to
So it
Parkland Trust.
replenishes the
I mean, the
funds.
issue that was raised with respect to the per unit fee is that we charge $5,000 for a single-family home. We charge $5,000 for a studio apartment.
Right, so, right, I see where you're at with this, but I also believe that multi-dwelling complexes could have more of an impact.
No, I mean,
Right.
because they don't have backyards, you can certainly, right.
Right.
Right, so I say, this is a case by case. My last question is, though, you said under the law, the planning board decides if land is granted, or?
So, well, the planning board has
That's,
to,
that's,
the
yeah.
planning board has to make the finding that there is not sufficient recreation land available on the site. So that's a requirement under town law 276.
What if they don't make that finding?
Then the imposition of a recreation fee is void.
Right, then we have, in other words, the planning board would be deciding if the town receives land. Is that correct?
So the planning, right, so and that's.
Yeah, really.
So, no.
It's a negative.
Right. So the point
Planning
is,
board has to make a finding that there is not land on the site that can't be used for recreation purposes.
right, so over the years, if you look back over the years, and you see these large tracts of land that we have all over the town, it's not the town board that's sitting there saying, okay, let's accept this one,
Right.
let's accept that one, no, these are products of projects that the town planning board decided that there was land available, therefore the $5,000 was not applicable in those cases. So,
In essence, the law is saying, the default under the law is that The statutory preference is land for
Yeah.
recreation will be set aside.
And I've heard this at the Association of Towns, and it irks me because we're at the point where it's like, enough with the land.
Right, and that's,
Site visits were actually done.
Exactly.
Look at some of those paper roads or paper circles and around the parcel access. You know, there's stories associated with every one of those where it says Town of Wapacher and it's like a circle. It's because it was a project, it was adjacent to a project that got done, and they said, okay, well, that's land instead of money.
I mean, we've got, some of them are, old water towers and things.
Right,
My
right,
favorite was in the back of Tall Trees.
Oh, yeah, yep, up to Montclair.
So we still have those.
There's two parcels up there.
Yep.
One was
Yeah.
a water parcel and one was a recreation parcel. They looked exactly the same.
Right.
And the land is like this.
It's on a
and
45-degree
And
angle.
it's parkland.
And that's the land I want to use to run a fire hydrant up to the top of the hill. That's
Right.
That's where your playground.
I want a fire-rated hydrant. I don't care how we do it, because the water system in Montclair does not support firefighting operations. If we have access to that water main, it's going to cost money. We're not going to do it tonight. But that's the land that exists. That's how we get it there. And
Because that's where the storage tank was for
Right.
Tall Trees.
Right, so we'll discuss that at some point in the future.
Actually, what we want to do is we're going to put a piece of property aside for you so you could build your little playground over there. Is that okay?
You're going to give me a playground on a 60-degree angle. I know how you guys operate in Ward 4. Thanks. That'll be fun. Sorry, go ahead, Barbara.
That's all right. So some of the other ones were just to bring all the fees in conformity, that commercial building permits are $250, and there were a couple under the fire inspectors that were $150, so to just bring them in, he does a lot of review on these, so to make them in line with the other ones. We have a new charge for EV stations, they're becoming very, very popular. Commercial variances, they're $750, and I'm looking to increase it to $1,000 because there's a lot of work that goes into them. And almost always we need an attorney to represent with the ZBA. So there's a lot more fees that come in on the backside from everybody getting involved. So those are some of the highlights. Oh, architecturals versus conceptuals. Conceptuals have always been $250, and when we designed architectural, I think there was an error. It was supposed to be the same price. So I just want to bring that back so that they're both the same amount. It just gets very hard in the office when there's so many different fees and different categories. I'm trying to bring a little continuity to them.
Now, is the EV permit for residential or commercial?
Either. Residential would be a typical building permit,
Okay.
and for commercial, it would be more, because commercial is more.
Yeah, I mean, my concern is with the rapidly changing landscape here, folks are putting these EV charging stations in their house, and that requires a building permit,
That
correct?
requires an electric permit, because it's just an outlet. If they're putting a standby generator, that's a building permit, that's higher, because that needs site visits.
So we're getting eyes on these installations.
So they need an electrical, somebody to sign off on that, right?
So we don't do electrical
I
inspections,
know.
so we have a list of third-party electrical inspectors. So for something like that, we wouldn't go out for a plug, so it's just us doing the paperwork for $50, and then a third-party electrical inspector will do their inspection and send it to us. But if it's a standby generator, now we have to go out, there's more involved with the plans, placement to the house.
Yeah, like I had a transfer switch put on the outside of my house, so that required, they had to run it from the panel and all that. We went through the electrical inspection.
Concern is some of these off-the-wall EV charging stations.
Yeah, so EV charging stations, you're saying that we should have a record of each one that's put into a residence, right? We should have a record of that?
Well, yes.
Okay.
One, the same way if you upgrade your service or you put in central air, anytime you do electrical,
Assuming they get a permit.
assuming.
Well, yeah, that's the
Well, I mean, there's unique challenges with firefighting with these EV stations, and we need to have, just like solar panels, the fire service needs to have, and we do have all the solar panels on our, on our tablets. We know if we're going to a residence that has solar panels, it does present unique challenges, the same as these EV stations. You get a fire in a garage, and there's an EV
So we can do
station.
that also. We started that, I think, about a year or two ago, where we send all the fire departments any new solar installation.
Yes.
So we could also add that for EV. I have some places, Chelsea Ridge and Village Crest, they're putting in 50 to 100 EV stations throughout their system.
Complex?
Excuse me?
They're within a complex,
Yes.
those ones? Yeah.
Yeah.
Yeah, those, I mean, those are visible, and yeah, I agree that we need to know about those too, but, you know, you're driving through an apartment complex, you see those.
Sure.
But when you have a house fire and, you know, first of all, an EV presents unique challenges to begin with, but it's good for us. We're going to a call, it comes right up on our tablet that this is what that residence has in it. And that's only based on the information we get from the town inventory, so.
So I'll add that tomorrow.
Thank you.
That all EV, new EV, and we can even do a report for the firehouses like we do with solar.
Sure.
And just so they know everyone that's been.
I want to know wherever there's an EV charging station in a residential dwelling, because there could be an EV in the garage, which is
Most
another whole.
are.
Yeah.
Some of them have, besides just the outlet, they have these very big battery backups.
Right, that's the concern,
And
yeah.
that would be an issue in a
Yeah.
fire.
Okay, so
The
if we can.
battery thing is a major,
It's a real
Major
challenge.
issue.
Real challenge, so I appreciate that. Thank you.
So do we want to, seems to me there's some more questions that need to be answered. Do we want to either have a workshop session on this, or do we, we just want to have Barbara come in 2 weeks and give us some of the updated information? What's your preference?
I think I would like 2 weeks to look at this a little closer. This way we can communicate with Barbara if we have any questions. I want to be able to take a look at this and evaluate it.
And keep in mind, this will require a public hearing, correct, Jim?
of course.
Yeah, so, procedurally, we've adopted the fee schedule by local law.
Yeah.
So it has to be amended by local law. And then this is the building department fees and zoning and planning fees. There's a couple of other fees that are in our code, collateral loan brokers, peddler's license, dog licenses, things like that, which appear in the same section. I haven't heard any, things regarding, requests to change those, so we would leave them as they were. That's about it.
What about 1203 inspections? Where are we at with those right now?
We've been doing very, very well with them. We're also, Howie's been doing an incredible job of discovering places that have never had it. And so he's making sure that they have their inspection yearly. So when you open a new business in the town, we combine the change of occupancy with the 1203. In the past, we didn't, but he does the inspection as a 1203, so that will start their first operational. And then it helps him because then it's calendared for the following year to remind them.
How does it work with respect to 1203 public assembly or places of assembly? The fee, is there a square footage fee, or
No,
is it?
It's a straight fee.
Should we look at, if you're doing a Hannaford's versus doing a, Girl Scouts at Wappinger Plaza, I mean, you're talking about a significant difference in square footage. Is it something we should look at, perhaps?
I think that's a good idea. I will sit with Howie tomorrow and talk to him about it, and then I'll send you all an email with his recommendation.
I mean, I just happened to look at, I don't know if you've taken a ride up to Hudson Valley Office Furniture yet,
Yes.
in Alpine. That is huge. I mean, it's taken, it looks like AC Moore, Salvation Army, it's either 2 or 3 units there.
It's taking up at least 2 units. huh?
That's a huge square footage, which is good. I mean, it's occupying the building, which is great, and hopefully the other space will get occupied too. But when we do these inspections, I think that there should be a proportional difference between that and a small office.
Oh, I agree.
Okay.
It just was never looked at, so that's a great idea.
Okay, thank
So we'll
you.
look at that tomorrow and then send the recommendations from the office.
All right, so we agree we're going to wait 2 weeks then?
Yes.
Motion to table.
Yes.
I'll make a motion to table.
Second.
Second. All right.
Motion second, all in favor?
Aye.
Any
Thank
nays
you.
or abstentions? Seeing none, motion
Thank you.
passes.
Thanks, Barbara.
Thanks, Barbara.
The last resolution here tonight is a Resolution 2023-48, acknowledgement of the correspondence log.
Moved.
Second.
Motion second, all in favor? Aye. Any nays or abstentions? Seeing none, motion passed. Any new business for special consideration?
I just want to say, I know we took a moment at the beginning of the meeting to pause. It's yet another day of tragedy here in this country with respect to the situation that happened in the Nashville area. And, these types of situations are happening at a rate that has never been seen before. We have proactive discussions with our partners at the Sheriff's Office, and now Brian Davidson is the new station commander at the State Police. I think it would be beneficial for us to see if there's any gaps in our town with respect to law enforcement presence in our schools. There's always a lot of focus on middle schools and high schools, and I believe there potentially is a gap with elementary schools that perhaps we as a town can find a solution to improve security. We have Evans Elementary School right here around the block, Myers Corners Elementary School, and I don't think the elementary schools have an SRO presence because there's been a focus on high schools and middle schools. And if this town needs to assist with improving security in our elementary schools, I think that's a conversation we should have. I know that there are challenges with funding school resource officers, and I think we need to explore if there's a way we as a town can assist. I mean, we have a contract with the Sheriff's Office. We utilize them in an effective way for quality of life patrols. And in previous years, during times of high anxiety for our parents of children, we have moved our resources into the schools. We've done this before, and I think it might be beneficial to have that conversation again. As unfortunate as it is, we need to work together and collaborate, continue that collaboration to ensure we have the highest level of security for our kids.
I agree, and I think we should also include, like, Randolph School. Any
Agreed.
schools.
Yes.
I really do. We should focus on this. This is our future. Unfortunately, things like this happen, and there has to be a way to stop it. But thank you. I agree with you wholeheartedly.
That's all I have. Thank you.
Okay, anybody else? Okay, next item would be a motion to go into executive session. I believe we have two items. One is with respect to the collective bargaining agreement. We have an issue that's come up with respect to that, and then also I think we still wanted to talk a little bit about the security issues. So I would move specifically to discuss the security items that we had discussed previously concerning the system, and then one specific item on the negotiation with respect to the CBA.
I'll make a motion to go into executive session.
Second.
Okay, motion second. All in favor? Aye. Any nays or abstentions? Seeing none, the motion passes. Thank you, everyone.